Live stream audio test. Good morning, everyone. It's 9:30, so I shall resume this inquiry. My name is Luke Fleming. I'm the inspector appointed by the Secretary of State to conduct this inquiry. The appeal is that made by Beechcroft Land Limited under the provisions of Section 78 of the Town and Country Planning Act 1990, and it's against a failure of North Somerset Council to give notice within the prescribed period of a decision on an application for planning permission for a proposal which is described as outline application for the erection of up to 62 dwellings, 30% affordable housing, alongside new access, landscaping and other associated works, with all matters reserved for future approval apart from access at land to the east of Church Lane and the north of Front Street, Churchill. So for clarification, it's an outline application with approval being sought for matters relating to access only. Usual reminders: mobile phones, please, and other devices, set them to silent. Attendance sheet should be circulating. Please sign it and return it by the end of the day. Thank you. I'm told there'll be no fire alarm today, but if you do hear it, the exit to my left, but also alternatively out the main doors and assemble in the car park on Walescote Road. There's no interested parties here today, I can see, so we can skip that bit. So today is day 6. I'm hoping will be the last sitting day of the inquiry. It should be. I've got a fair bit to speak about on conditions, less so on the obligation, so the bulk of the time will be spent probably on conditions. So I'd hope to do that in accordance with the timetable that I'd set out in the programme. Really, it might take a little bit longer, but if it does, site visit. I've decided I'm not gonna rush and do that this afternoon and try and fit it all in. I was thinking about there's quite a lot of ground for me to cover on that site visit, so I'm going to, probably the only change of the programme is I'm going to do that tomorrow. Okay, so you're happy for that to still be unaccompanied? Yeah. Does that make any difference to anybody here if I do that tomorrow morning? Yeah? Fantastic.
No, that's fine with us, sir.
Yeah, it just means that I'm refreshed, and I'm not feeling under pressure to complete it within sort of a space of time. So that's what I'm going to do. If anyone does approach me on site, as I said before, I won't be discussing the appeal with anyone. And if anyone is watching and thinking of approaching me on site, don't think me rude if I don't discuss the proposal. It's very much I can't discuss the scheme without all parties being present, and as I said, I will have already closed the inquiry. So please don't approach me if you do see me on site. Okay. So all that said, is there anyone that anything that anyone wishes to draw to my attention? We're not as Mr. Leader outlined yesterday, he's otherwise engaged. I think he'll just, no doubt, would expect the lawyers to come in as and when through the course of the day. Is that what we're expecting?
Yes, same applies to Mr. Garvey as well. Mr. Garvey's going to join us for the closings.
Okay.
Or at some point.
Okay.
Sorry, sir. Can I just mention, Mr. Leader's mentioned a couple of times throughout the inquiry, we've taken a cut of the viewing figures of the live stream. So that's factual information taken from the council's YouTube channel. So can I hand in a copy of that, please?
Yeah, have you got a copy for
Yes,
all of us? I think we said that we were going to accept those, so that would be great. Thank you. Again, record that on the inquiry documents, please.
Thanks. Sir, just on the matter of the site visit, the itinerary, would you like a hard copy of that now, or?
If it's done, well, it's not going to change, is it? So we may as well have that so we don't...
My colleague will pass that to you.
Yeah.
That's as agreed with the council, so no surprises.
Okay, and we're 100% satisfied there's going to be no issue with me accessing any of these locations? No. Okay. Okay. All right. Well, maybe I might need to come back to that later, but we can... Oh, yeah. Thank you very much. Just put that there for now. Right. So, unless there's anything else, we'll start with the roundtable session on conditions. Okay, so it will be a roundtable session, which I shall lead. I presume that I'll be directing questions in the first instance to Mr. Wakefield and Mr. Stevenson. Is that correct?
That's correct, yes.
Okay. Obviously, anybody else at the table is not restricted from getting involved if you can help. There's a gentleman to your side, Mr. Stevenson. Do you want to just introduce him to me? He looks like he's ready to engage in this discussion. So,
Of course, sir. This is Roger Wilmot, manager for the strategic developments team. Mr. Wilmot will be dealing with the SIL compliance and Section 106 details as well. He may have input to the conditions if deemed necessary, but we will discuss that as we go through.
okay. So, obviously, sign the attendance sheet, Mr. Wilmot. Are there any qualifications that you want me to be aware of?
Sorry, I've got a diploma in town and country planning and a diploma in management studies.
Okay. Let's put those against your name on the attendance sheet, just for completeness. Okay. We've got a schedule of suggested conditions. We've all had sight of that. We're going to go through each condition one by one, in sort of fairly usual way. Have you had a chance to sort of engage on that since that's been sent to me? Has the thinking gone any further than this schedule?
It hasn't gone any further, sir. The comment that you noted earlier in the inquiry with regard to the SPA issues, etc., I think we concluded in our own minds and sort of reaffirmed it last night was that the position and how that matter relates to the conditions is acceptable rather than needing to go into the Section 106. We're happy to take further comments from you on that particular matter, but I think the conclusion we reached based on the advice that Mr. Garvey offered you was that conditions are acceptable in relation to that particular matter.
Okay. All right, well, we'll bear that in mind as we go through. A lot of the... Just give some context for some of the discussion points that we'll have on the conditions, because it might be quicker. So we probably would want to have the shadow HRA sort of open in front of us as we look at the conditions. A couple of general principles from that come to my mind in looking at them. It seems to me that the habitats to be provided as part of the development, foraging or whatever else, you don't want anything that's going to delay them from sort of being put in place and the opportunity to become established, to in part sort of retain them through the lifetime of construction, but also to allow them to become established. So I think as we go through, we would have to anyway, but we've got to look at the any pre-commencement conditions very carefully and ensure that any work necessary for those reasons to facilitate the habitats isn't precluded from sort of taking place as early as possible.
Yes, sir.
So I'll give that context. I presume you'd agree with that.
We would, sir, yes.
Yeah.
We would, yes.
So as we go through, we probably I'll suggest and probably be consistent that there'll be a number of changes that will just allow that habitat work to take place sort of early on, I think. The other principle that I'm going to just flag up now, and it does sort of stray into the 106 discussion, is the shadow HRA does talk about, rightly so, monitoring and maintenance of the habitats, doesn't it?
It does, yes.
So there is in the 106 contributions towards maintenance of open space, but there isn't necessarily any contributions in the 106 that explicitly refer to maintenance of the habitats. So as we go through, generally I think it's clear and I think it's acceptable that the conditions do require a detailed ecology management plan. That's obviously going to be informed by the detailed reserved matters, and that's rightly so, that principle. That such plans should set out those details for sort of monitoring and maintenance. But my initial concern that's coming to my mind is if there is a fee attached to that maintenance over and above what's in the obligation, I'm concerned that we shouldn't necessarily be seeking to secure that through planning conditions, and it should be in the obligation.
Ordinarily, sir, if the open space is passed over to a management company, the scope of management works would be, and maintenance works would be agreed with the management company, which would therefore encompass those ecological maintenance works, and that would then be included in the fees or monies to be paid to the management company for the ongoing maintenance of both the open space and any, or sort of the wider open space, and then the play areas, etc. as well. So one would normally expect the management company to take that into consideration in establishing what monies they would charge to the residents for the maintenance of the various open spaces.
Yeah. Okay. Well, I'm saying that now, almost a precursor to the discussion on the obligation. I think we probably can get on and work through the conditions, but that's my, if you like, comment and if you like, a concern that I have, that I want to sort of make sure that I've got a clear answer to, that I'm satisfied as we go through and deal with both matters. Okay.
Yes, sir. Very good. Yep.
Okay. So we'll leave that where it is for now, but we'll start to, and we'll go through the. Do you want to have a chat about that? Do you need a few minutes to have a chat about it before I start to do the conditions? I'm happy if you want to have a.
I don't think so, sir. Maybe if we start going through the conditions and if it comes up and requires a separate chat, then
Yeah,
we could request
let
that
me
as
know
well.
if you need a short adjournment to discuss, possibly with the council. Yeah.
Sir, I think it actually would be quite beneficial to have a quick chat on that, so then we can
I,
hopefully take a clear position.
I think it
when we
would
come
be
back to you.
useful for you to briefly just see where you both are on it rather than...
Okay, very good, sir.
So how long do you think you need?
5 minutes, sir.
Well, shall we say 10?
Okay, very good.
So we'll take a brief adjournment until 5 to 10. So at 10 o'clock the inquiry is resumed. Okay, was that helpful to you?
Oh, sorry. I think it was, sir. I think the position we've concluded on is that between both the conditions and the Section 106, the parties feel that the ecological interests are suitably covered. I don't think the council has suggested that a different approach has been taken, or materially different approach has been taken on any other site that's been affected by similar constraints to the one affecting this site. So the conclusion, as I say, is that between the two, they are suitably, the interests as far as the SPA is suitably covered.
Okay.
I don't know if Mr Stevenson wants to add anything further to that.
No, I think that's a fair reflection of the conversation we've just had. Yeah, we're in the
All
same
right.
position.
Well, as we go through, we just bear that in mind as we go through. Right. Okay. So we'll work through the conditions one by one. So I sort of have the schedule in front of you. What I'm looking for really, there'll be a number of changes that are needed, and I think I'm looking for those changes to be agreed, and then ultimately the parties would agree a final updated schedule of conditions to submit back to me after the inquiry. Is that how you'd see it?
Yes, sir.
Yeah.
Agreed.
Yes, sir.
All right. All right then. So conditions 1 to 3. They're the standard timescale conditions. Nothing to say about those unless you want to say anything.
No, sir.
Condition 4. The only point that I'll make is the plans condition. For the avoidance of doubt, can we include the full titles and drawing numbers as detailed on drawings H1 to 3? I picked up that I think 194414 is not the correct drawing anyway, which you'd agreed. So it is literally as is listed in H1 to 3, I think, in the core documents is what really that condition should say. Do you agree?
Very good, sir. Yes.
Okay, and then condition 5 relates to a construction management plan. No issues with it generally. I think just for certainty, I'm not in favour of conditions that refer to a plan and then they refer to details or a schedule. So, and this one, I think it can just be tightened up if you abbreviate CMP after construction management plan, and then when you refer to the plan and what it should include, say that the CMP should include details of. So there's no doubt that you're not referring to anything other than that construction management plan. Okay, so if you're happy with that.
Yes, sir. Agreed.
And then further on in the condition, then the last sentence before the reason, it then says, in accordance with the approved details, substitute details for CMP again, because the details are the CMP, aren't they, not anything else. Anything else on that? No?
No, sir.
Stop me if I'm going too fast, or, you know, it's important that you capture the changes, and I'm not wanting to rush. So condition 6 is about ultra-low energy vehicle infrastructure. To get that in my mind, that's concerned with charging points then, is it? Is that necessary?
Well, I believe as of today, that's now Part S of the building regs, isn't it?
Well, I was hoping you'd say that.
Yeah. So, by that effect, it's moved elsewhere, so we could omit that one on.
Yeah, I think
that
that's
date.
right. I think general principle, there's no necessity to repeat other regulatory regimes, so it's quite novel that it's today.
Good
But
timing.
I think the provisions in it required you to consider when it would be implemented anyway, so it's not that novel. I don't think that it's today, but generally not to labour on it, so I think that needs to be struck out.
I don't want to jump ahead, sir, but the same would apply to 28, which is also linked to electric vehicle charging points. We can come to it when we get there. but Same principles applied. Just have
Spotted
it in
that.
mind.
So number 6 would be deleted. That's good. That saved us a bit of time, your response there, Mr. Stevenson, so that's good. So the condition 7, we're now on to sort of the ecology mitigation, if you like. This is about the lighting strategy. I suppose pre-commencement, why does this need to be pre-commencement? Because the lighting deal is also to do with construction lighting as well, is that? Or
Well, the purpose of this condition is more in relation to the SAC and the impact of development on the BATs.
Yeah.
So that's how we've taken it in rather than construction phase. Sorry, it does. Yeah, that is including the construction phase, so it is from.
Yeah,
sort of day one.
I'm satisfied that this one. There's others relating to ecology that I probably don't think need to be changed from pre-commencement to allow habitats works. But this one, for lighting, unless Mr. Wakefield's got a comment, I think it justified being pre-commencement.
I don't have a comment, sir.
Right. Okay. So here, and there'll be a recurring theme. The shadow HRA does include if you like, a lighting sort of strategy, and I need that to form a view on, well, to undertake the appropriate assessment. So rightly so. However, you know, that will change subject with the submission of reserve matters, etc. So, but in order to provide the degree of certainty, I wonder whether this condition should say that lighting strategy should be in accordance with the shadow HRA.
Yes, we would be happy with that, sir.
Yeah.
Yeah, absolutely agree with that as well.
Yeah. So what that would be then, I think, just to where those changes could go in, my suggestions is where the condition starts with this shall, you could insert a sentence there that would say be in accordance with the shadow HRA by Ecology Solutions May 2022, and show all of those things. And I think just to recognise that this go. So did you get that? So it's all right for me talking. You're trying to note that down.
I did. Did you say February 22?
May 22.
May, sorry. Yeah, I was going to say because the
Yeah,
document said
May
May.
22. All right. So when I ask for that to be inserted, that's what I mean, and I'll just say shadow HRA from now on. But after this shall, if you put that reference in, and then to recognise that a more detailed lighting strategy is needed, I think that the sentence which starts with these details shall include a detailed undertaken a detailed assessment. I think just the word detailed will assist to say that it is moving on from what we've already got in the shadow HRA, is my suggestions.
Yes, that would make sense to us. Happy with that.
Sorry, may I just sort of ask one point of clarification? Just at the moment, obviously, what we're referring to is a shadow HRA. Ultimately, the condition presumably will need to reflect the fact that at some point that shadow HRA will become the adopted HRA. So it's just a question of, I suppose, the final terminology as to which one we're referring to.
No, the shadow HRA is the document that sets out the mitigation that I'm required to consider in undertaking the appropriate assessment. So it is exactly what that document is that I want to be referenced. So it's very important that we get the date and that document referred to accurately. Okay. So those changes clear? Do you agree with those?
Changes are clear and we agree with those.
Same, yes.
Okay. Okay, so condition 8. So yes, this right. So the purpose of this condition, just briefly explain it to me.
The biodiversity protection plan is effectively otherwise known as a construction environmental management plan. To all intents and purposes, do the same thing as that.
Yeah.
And obviously, therefore, to protect the biodiversity interests of the site during the construction process.
Yeah. Okay. Okay. Yep. So I wonder whether this, again, should this be a pre-commencement condition? Should it?
I think it should personally, because it's there to inform the construction process, sir.
Okay.
Yeah, that is our take on it as well. Perhaps one point of clarification, and we agree that it is sort of, in all intents and purposes, construction environmental management plan. The end of the, or towards the fourth line, erection of a bat box, whether that to be, it seems to refer to just a singular bat box, and it may be better as bat roosts. If there's any thoughts on that.
I was going to mention that. But yeah, I think bat roosts would be better. Okay. Okay. All right. On page 4, where it says the BPP shall include measures, again, I suggest inserting that the BPP, shall be in accordance with the shadow HRA and include. So you're happy with that?
Yeah, happy with that. I'm assuming when referring to the shadow HRA, that will then also include ecology solutions May 22.
Exactly, that
Yeah.
full title and date, please. And then on page 5, work shall be implemented in strict accordance with the approved rather than methodology BPP. Happy with that?
Yes, sir.
Anything else on that condition?
No, sir.
Condition 9, again, pre-commencement condition. I think nesting birds and bat roosting, I think I'm happy with that.
Yeah, there's an element of overlap, but yeah.
Yeah, is there an element, is the point, is that condition needed when read alongside?
Well, where the BPP refers to bat roosting, this expands out to bird nesting and so on like that. So, in theory, you could take the bat roosting out from that, but the bird nesting is...
And put bird nesting into the previous condition.
Yeah, that could be done, yeah.
Because the BPP is going to deal with it's biodiversity, isn't it? Not just bats.
My only query with that, sir, is, as I see it, condition 9 is to deal with, let's call it the occupation and post-occupation of the site as a housing development, whereas condition 8 is dealing with construction.
Yeah.
And therefore, to my mind, they should be separate conditions. And the question then is whether or not it does need to be pre-commencement or otherwise. We don't have a problem with it being pre-commencement. Coming back to one of your earlier points, I'm not sure it's probably the best example, but back to one of your earlier points to make sure that things are being done from a habitat and biodiversity perspective in good time. I'm not sure it's absolutely critical to that, but still, we don't have an issue with it being prior to commencement.
So, okay, not to go back over old ground. Okay, yeah.
So as a quick point on that, if the appellants are content that they're okay with it being a prior to commencement, just a note that I would raise is that that would be useful if any elements were being included in the fabric of the building, say. That would allow that to be identified at an appropriate time. Okay.
All right. Yep. I think I'm broadly happy with that condition. I would say the last sentence, the development shall thereafter be carried out in full accordance with the approved bird nesting and bat roosting strategy.
Yes, sir.
Okay. Condition 10. Substantive development. I've got an issue with that. It's sort of precision and what that actually means. I can understand the aim of the condition and why it's necessary. I don't think it's sufficiently precise to refer to substantive development. So I wondered if you could think about what it's trying to achieve and whether you could suggest a more precise form of words. Yeah, is it occupation of a dwelling? Is it a particular stage of construction, or?
Good question. I think the point being is that the ecological surveys and so on like that are time sensitive,
Yeah.
so it's to make sure that whilst there's case law about the implementation of a planning permission, if that were to be extended beyond the reasonable lifespan of the surveys, then the requirement would be almost to rerun those to ensure that the position either remains the same or in fact needs to be revisited to achieve the necessary aims. So substantive development in terms of what that may be could be sort of up to DPC level, for example, because then there's a clearly defined position that is where the works may go to. So that's sort of the footings, the beginnings of it, but does that need to be redone? Or that could be enabling works, would perhaps be a clearer one, I think. Yeah, sort of on reflection, I think enabling works would be the better, because then if there did need to be any adjustments, that is the opportunity to look at that again at that stage.
I'm not sure enabling works would take us any further on, because it, again, we'd be left with sort of knowing what would be enabling works.
The only other approach we would suggest, sir, is that it just ties into should development not have commenced within 3 years, and therefore you just remove the words substantive effectively, because once you've effectively got to that stage, the BPP will have been approved and you'll be into that, or you'll be tied into that. So that would effectively cover the matters I think the council are concerned with in that respect.
Yeah, I think I can agree to that.
Okay. So the wording that you propose, then, do you want to just tell me again, just for the avoidance of doubt?
Yes.
You don't need to rush. You can read it, but what?
It would be should development not have commenced within 3 years of the date of this permission, then an updated ecological and protected species survey shall be submitted to and approved in writing by the local planning authority. This shall include a full written schedule of how the updated survey work has informed the details to be subsequently approved under a reserved matters application.
Is there an issue there with the fact that you could, I'm not saying you would, you could commence development, submit all the details, commence the development, and then cease construction? Is it about, it's almost about implementing the permission, isn't it? So is there a need for further comfort from the council side that the development wouldn't simply be commenced and then cease? Does it need to be linked to occupation at all, or?
I have to say, sir, I'm not this is one of those conditions that I'm not particularly familiar with. I've not come
yeah.
across. I've not come across
It's
before.
probably a question for the council, really.
It's one that we don't have an objection to per se, but I'm not. I
Yeah,
don't-
yeah. So really for the council to...
While the council are considering that point, I mean, the scenario that you just painted then, I'm not sure that planning permissions can work in the event that that does occur. We don't really see it often occur in this country at all. I can't, other than maybe a brownfield site in a town or city, I can't think of anywhere where it has occurred anywhere else. I'm just not sure the planning system can work on the basis that that might occur at some point.
Yeah, I know what you mean, but there are instances up and down the country, but
I say, yeah, sorry, we've been reflecting on the points you've raised, and I think in light of what has been said, it may be appropriate to drop that one. The condition, sorry.
to drop the condition. You don't think it's needed?
I'm not entirely sure what aims it's really going to get, other than what we've got secured elsewhere within the conditions and within the permission were it granted as well.
So the ecology management plan itself will have review mechanisms in it and monitoring as well, won't it? So, okay. Agree. I'm not sure what effect it has. So 10 is to be deleted. Um, 11 is the ecology, the landscape and ecology management plan, which is, I think, quite a significant thing in relation to this development. Again, I'd actually I wonder whether this, rather than pre-commencement, should be other than the establishment of habitats, including through planting and replacement of hedgerows, erection of bat roosts, no development shall commence until.
Sorry, could you repeat that? I lost it with the...
Other than the establishment of habitats, including through the planting of replacement hedgerows and the erection of bat roosts, no development shall commence until a landscape and ecology management plan. So again, that point that there may be other things that allow you to, if you like, to start to get the habitats up and running, and then obviously the construction phase as well. It's going to require some measures to keep, for example, continuity of the hedgerows, etc. May or not be development, some of those things, but they would avoid doubt.
We'd be happy with that approach, sir.
Okay, so other than the establishment of habitats, including through the planting of replacement hedgerows and the erection of bat roosts, no development shall commence until a LEMP has been submitted to and approved in writing by the local planning authority. So then the second sentence, which talks about the content of the LEMP, I think that should start with the LEMP shall accord with the shadow HRA full title and shall include. Does that, their suggestions, does they sound reasonable? More
Yes.
certainty, precision?
They do, yes.
So then the last sentence, the LEMP shall be implemented in full accordance. The LEMP shall be implemented in accordance with the timetable set in the approved details. So, yeah, I suppose you'd implement it, and then I'm thinking it's continuity really. So I'm thinking it should say shall be implemented and retained. So the implementation is retained. So you can't implement it and then just move away from it. In full accordance with the timescales. So it's about timing set out in the approved details. Yeah. Yeah, it refers to LEMP in that sentence, so approved details is okay. It could say approved LEMP. I think it'd be better to say in the approved LEMP rather than details, because again it's referring to there being something else other than what's in the LEMP. Happy with that?
Yes, happy with that, sir.
Yeah,
Makes sense.
Then it's clause 10. I'll just draw your attention to it. Details of the legal and funding mechanisms by which the long-term implementation of the plan, again, I think that should be LEMP, will be secured by the developer with the management bodies responsible for its delivery. So the LEMP's going to identify these funding mechanisms, and it'd be long-term implementation, which is really over the lifetime of the development, really, isn't it, the LEMP? So this goes back to the point that I'd raised at the start, is the sums that are going to be needed for that, are they adequately reflected in the 106? There's some sums in there for maintenance of the open space. I suppose when we get onto it, we can look at it in detail, but what I will say is the 106 doesn't mention the LEMP in any way. It doesn't mention it really just talks about open space. It does talk about conservation site, and it does talk about different components of the open space, for example, woodlands, etc., but it doesn't specifically talk about ecology management. Do you want to say something?
Well, there certainly have been other agreements that I can recall where that obligation has possibly been made more explicit actually within the body of the agreement. So it's been made explicit that that's part of the management company's role. I think from the discussion that we had during the brief adjournment, we had looked, I think in particular, at clause 10 of condition 11. And I think we felt probably what was critical on that was that the local planning authority, when it is approached for discharge of condition 11, that we are very diligent, I think, about looking exactly at the proposed funding arrangements, and that we are wholly satisfied that those funding mechanisms are in place, as it were, in perpetuity. So I think we felt that certainly that it was this was a route in which the concern that you raise, I think, can be addressed, albeit, as I say, in some other agreements we have made that more explicit. I think in terms of the agreement as it's currently drafted, the management company, as you've correctly identified, has a responsibility for a number of categories of open space, which include woodland and conservation sites. So it does do that, but there is no specific sum of money which is proposed for maintenance unless the open spaces are proposed to be transferred to the council or its nominee. In the case of management companies, in my experience, almost invariably they are funded through effectively charges on the service charges on the individual householders.
Okay. So the figures that are in the restraining to the 106, that are in the 106, drawn from the developer contributions SPD, that's right, isn't it? Is it? Yeah. Is the council satisfied that those figures account for the management and implementation of the LEMP?
My understanding is that the figure which is referred to as the open space maintenance contribution, that is specifically for the maintenance of the locally equipped area for play equipment. So it doesn't cover, for example, general maintenance of the proposed open spaces.
Yeah. So, as I said, my concern is that this clause 10 is effectively going to require a sum of money, isn't it? In maintenance.
I think the appellant had assumed that the money set out in the section 106 and the breakdown provided within that, where it refers to woodland habitat, etc., would address the maintenance of the development, not just in terms of uses, play space, etc., but the ecological aspects of the open space as well. I think that was the assumption that we were making, sir.
Yeah.
I mean, in this, so that deals with our assumption in terms of if the open space is to be handed to the council. In the scenario where the management company was to take on the open space and its requirements, the works to be undertaken with the management company would be established in the agreement between the developer and the management company. The management company would then establish the monies to be paid by residents for the specific works to be undertaken, and those monies would then, obviously, as we just said, those monies would then take account of all the elements of work to be undertaken, including any additional monies that might be required in the future to address shortfalls in the LEMP's objectives that aren't being met. So, for example, personal example, I live on a development where there is a management company in play. The management company, I know from the developer at the time, Persimmon, had effectively a role of objectives and works to carry out. They based those works on the annual sum of money which I and other residents have to pay. If additional works are necessary to meet other objectives relevant and pursuant to the permission and the conditions within that permission, the annual sum of money then increases accordingly. Now, some councils, including this one, refer to the fact that some residents complain in the sense that their annual payments are going up, but that's effectively, as I understand it, that's just part of the course, that if the payments need to increase because additional works are being carried out, whether that be vandalism to the play space or additional works needing to be carried out to satisfy ecological objectives, that's just what happens. I don't know if that's helpful to you, sir, but so I suppose to summarise, we still are satisfied that on the assumption that those monies set out within the Section 106 cover not just play parts of the development, but also environmental/ecological objectives of the overall application, we are covered through the Section 106, both if the monies, if the open space is handed to the council and in the eventuality that the land is handed to a management company or passed to a management company.
Well, I think probably just to just try and clarify matters a bit further, I think in terms of the transfer of open space, I mean, there are effectively three options. One is that it goes to the council, in which case there will be a maintenance contribution effectively to be made, which will be in accordance with the categories of open space, because we effectively work to a schedule. We know fairly much what the sort of cost of maintaining different types of open space actually is, and that's contained in Table 1 on
and
page
would that cover the matters in the LEMP then?
Well, again, I think it would do, because that does include, for example, grassed areas with low-density trees, shrubs and recreation areas,
Yeah.
mature woodland. It includes things like open water and swales, various sort of things which perhaps are, rather more informal open spaces. So it does cover those,
Yeah.
but doesn't necessarily make it absolutely explicit.
Yeah.
That it is, again, to be managed by the council for direct biodiversity objectives.
Yeah. So I cut you off, and you were going to go through the other ways. I'm sorry about that. But.
Yes, I mean the second option is that we, as a council, nominate another body that we would consider to be appropriate, particularly for, I mean, that has been done on several occasions, specifically for biodiversity objectives. We do within the district have several volunteer bodies who are dedicated specifically and very expert in managing land for biodiversity purposes. And we have, within the last 12 months, through a Section 106 agreement, agreed a transfer of several acres of land with a sum of money to carry out biodiversity enhancements. So that's one option that would be open to us if there is indeed one of those bodies that's interested in taking over this land. And the third one is the management company option, which we've just run through about how that would work, albeit, as I say, in some agreements that I'm aware of, we have made it more explicit, probably within the Section 106 agreement, that the management company does indeed have a biodiversity management role, as well as it's just more grounds maintenance type role.
So, okay, so as we said, it's an outline application. The details aren't all firmed up as to how that's going to be done. That's why is required and why this clause 10 is needed. But in short, whichever, if you like, solution for the long-term funding mechanism, the council are satisfied that in that figure they've got for the open space maintenance, that took account of what would be required to maintain the habitats.
I think, so they are generalised figures which are based on our experience over, I think, decades of sort of maintaining open spaces of various characteristics. I think they are broadly reflective of the sort of costs and what we would require to maintain those open spaces if it were transferred to the council. I think it's fair to say that as a result of declaring a nature emergency and climate emergency, the council itself is very committed to managing its open spaces for biodiversity objectives, and indeed I think it has a programme for generally trying to rewild many of those open spaces, or at least parts of those open spaces, for those objectives. And I think budgets for maintaining anything for any council is always a problem, but I think that the figures that we have there are broadly reflective of what we would require.
Okay, all right. Okay, again, for the discussion when we get to the planning agreement, it may be that more detail is needed in there just to clarify that relationship with biodiversity and the habitats. But we'll talk about that when we get there, okay? Okay. Anything else to say on that condition?
Nothing from the appellant, sir.
No. Condition 12. I'm happy with the council's condition there. The appellant suggested an alternative one. I think the council's is, if you like, more detailed. It does at risk of repeating some aspects of the BS document, but I was happy with it.
That's fine, sir. We don't object to the councils. We've just offered an alternative in this one.
Condition 13. Again, is this a pre-commencement condition? It's materials. Is it about really the dwellings getting to slab level, or and then really you've obviously there's the boundary walls, retaining walls, yes, understood, but road surfacing and parking areas, that's the surfacing material rather than commencing works on those matters, isn't it? So I wondered if it needs to be adjusted.
Sorry, could you sort of clarify that point? I think we're a bit tired.
I think the detailed wording needs changing around a little bit. I haven't got a clear suggestion. It's quite basic. My point is that reference to dwellings, you're obviously concerned about the finishes of those dwellings, which is above foundation slab level, I'd suggest. Yeah? And then for the boundary and boundary walls, fine. They're obviously, I've got no issue with that. But then when it talks about roads, pavements and parking areas, again, I think you probably should caveat that to surfacing materials.
Yeah, I agree on that. That does make sense.
Yeah, so it changes it from a pre-commencement condition to allowing, if you like, basically the stuff on the ground to happen. But I'll leave you to, because it's a bit clunky the way it's worded, I'll leave you to sort of agree some wording, but my point is, it shouldn't really be pre-commencement. I think you should be able to get on the ground.
We'll have a look at that, sir,
Yeah.
with the council.
Condition 14, pedestrian links. I think prior to the occupation of the development, which could allude to all of the development, I think this one's about anybody living there, so I think it's probably prior to first occupation.
Yes, would agree with that.
So other than that, I'm satisfied it's needed. And then condition 5 is about visibility displays again. I think that's first occupation as well. So it would delete of the development and just say prior to first occupation. Suggest?
Agreed, yes.
And then where it says approved plans, we are approving the access, so you could just literally put as detailed in condition 5, or you could reference the drawings, but I think it needs a bit more certainty than just approved plans. I'd suggest as detailed in condition 5. That's just for the avoidance of doubt.
Agreed, yeah.
Okay.
You referred to condition 5. Did you mean condition 4?
Could well do. I meant the plans condition. Is it 4?
I think it's 4.
Yeah.
Yeah.
Yeah, so the plans
for your
condition. Thank you. Obviously we've deleted a few as well, so if I refer to any numbers, let's just make sure we're clear as well. So the plans condition. And then 16, again, it's just first occupation. Prior to first occupation, the access. And then the plan, reference the plans condition again. Uh, 17, I think that's right, prior to the occupation of each dwelling. And then it's just the last bit I've got a problem with, so the parking spaces shall be permanently retained. The last sentence says, unless otherwise agreed in writing by the local planning authority, so I suggest delete that. Really, it's a tailpiece element, alludes to something else being agreed that's not before us.
Were you happy with the first line as it's worded?
Yeah, prior to the occupation of each dwelling, yeah. So that would lead me to read that of, as each dwelling is occupied, their parking should be made available. So I think that's right.
That's the intention, yes.
Okay, so that's 17. Uh, 18. Yeah, I think that's 18 is covered by the detailed condition about trees and hedges, isn't it, on page 8? I agree with what the appellants say there, unless you tell me it does something different.
No, I think that's right. Having looked back at that with this in front of us, I think that's a correct position.
Yeah, so is it condition 12? Yeah, 12, so it's covered by 12, so we can delete that. 19, this is, again, I mentioned it before, it's the same wording that I gave you before that I suggest. Rather than no above ground work, I think it's probably other than the establishment of habitats, etc., that detailed wording that I gave you for the previous condition, the same wording. No development shall take place until.
Agreed. So, with regard to condition 19, do I take that you're content with the council's version there? 'Cause that's...
Yeah. Why, Mr. Wakefield? Why did you? Can you just explain to me why you, what you're aiming for with the alternative?
In simple terms, sir, that's a condition. Our suggestion is a condition that I see more commonly used, the wording, and as has been reminded now, more of a model condition in that respect.
Yeah. And this wording from the council then, has this come from the flood risk authority or the environment agency have been involved in it? Or?
It has. It's come from the drainage engineer, the lead flood authority. In discussion I've had with that officer, he's quite adamant that the council's wording is more precise. The alternative doesn't set out the sort of 1 in 30 year surcharging, 1 in 100 year property flooding, and would sort of be overly simplistic. So has given me information that the various lead flood authorities do discuss this at detail, and the council's wording is the sort of more updated version that the various authorities look to use and would use as the model condition.
I think it is a bit more precise and it leaves less to doubt than the alternative.
Very good, sir.
Okay. 20, again, no above ground work. Suggest that wording that I'd just given you again.
Agreed, sir.
Similar to the last one, I think that is more precise than the alternative. So unless you've got any comments, I'm minded to favour the council's.
No objection to that, sir.
Okay. Okay. 21. Yeah, I think this is the foul water. Prior to first occupation, again?
Yes.
Yeah. I think substitute details in the last sentence with scheme. It's talking about a scheme, so just for consistency.
Agreed, sir.
Anything else on 21?
No,
No.
sir.
22. Again, yeah, so we want the travel plan. I think, again, it's probably about not the occupation of any dwellings, isn't it? So it'd be until you've got this, the travel plan coordinator in place, etc. So how about no dwelling shall be occupied until, rather than prior to the occupation of the development that could lead you to believe that it's all occupied?
Yes, that's a better way of phrasing it.
Yeah, no dwelling shall be occupied until. Okay, yeah, principles, standard. Anything else on 22?
No, sir.
Yeah, 23 is about, obviously, waste, storage and collection. So we've got illustrative layout, but we haven't necessarily got firmed up details as to where that area is going to be. So I think we've got a condition sort of needs to be adjusted for that reason. So it's really, the aim is to have the waste collection arrangements in place before any dwellings become occupied, isn't it, really?
Correct, yes.
Yeah, so it should be prior to first occupation, and perhaps a space rather than the, because we don't know where that's going to be. Yeah.
Yeah, correct.
Shall be constructed and implemented in accordance with. What will it be in accordance with?
The expectation is that we would get a plan that would set out where each of the waste collection locations are, and so we could then ensure that there's sufficient for each of the dwellings, and there also would accord with the council's guidance on refuse collection in terms of carry distances from the property and so on like that. So it's
Yeah.
seeking to ensure those details are appropriate both for the collection of the waste but also for the future residents of the site.
Yeah, I thought you'd say something like that, and that's sort of why I asked. So again, I probably can't suggest what that condition should say, but it seems that it requires a fairly simple sort of waste management type plan, doesn't it? Mr. Wakefield, I'm not. You can't tie it to the approved plans because there's nothing really on them that gives it anything that you can pin it to.
Don't disagree with that, sir. The other point to make is whether or not the provision of the space and facilities to be provided should be agreed in relation to each dwelling to be occupied rather than development as a whole. So
Yeah.
if we could have, if we can discuss that and agree that with
Yeah, I
council
think.
accordingly,
Yeah, I
have a
think
play
that's.
around with that condition.
Yeah, I think it just needs revisiting that condition to
That's
reflect
fine,
the
sir.
outline nature. So
Okay.
I'll leave that with you to agree what those details should be. So that's 23. I mean, the rest is right. Storage and collection and waste shall be permanently retained. I think that's right. It's just the middle bit. 24. Is this necessary? Is this an omission?
I mean, generally speaking, you would rely on the building regs.
Yeah, it's
No.
the council. Did you mean to put this one on? Was it the intention that this would be on?
Yes, it was. There was a point where I think we said, okay, we will not seek code level 4 dwellings, but we undertook a review of our supplementary planning document on sustainable buildings and places. I think that was in April 21, and I think it was those changes to that document approved, effectively seeking code level 4 on all on dwellings contained within schemes that were submitted after a particular date, which I can't offhand remember.
So the Code for Sustainable Homes, that's been replaced by the new national system of housing standards. So in principle, that element's not right. And then the other aspect is perhaps goes back to the point that we raised before about seeking to duplicate other regulatory regimes in this instance. So I'm not sure that condition can pass the tests.
We would agree, as I said, we have no objection in principle. Should it be concluded that it is necessary and meets the test, generally speaking, but agree with your point in the sense that normally one falls on the building regs to cover matters like this now.
And I don't think we have anything further to add on that other than to leave it to your discretion on that point.
All right. Well, I'm minded that should be deleted. 25.
So, as mentioned earlier on, we've agreed to delete condition 6 for the reasons that you mentioned, and I think this condition falls into the same camp as that.
Yeah, the difference here is perhaps this is a specific requirement of policy CS2, isn't it? Yeah. 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 I wasn't so fixed on, if you like. I think that this condition is justified by the plan and CS2. It's different to the previous one, which references the Code for Sustainable Homes, and it's different to the EV charging points one because this is underpinned by a policy requirement. So I thought that this was okay in principle.
Very good, sir. Our original objection was in relation to duplication. If you're satisfied and hearing the views given, I would tend to agree that it should be retained.
Yeah. Yeah, okay, so 25 would remain. 26, again, this is a requirement of DM42, isn't it?
It is, yes.
Yeah. So, I haven't got a problem with 26 on that basis. Uh, 27 is again a requirement of DM42. So on that basis I haven't got a problem with that either. Anything on 27?
No, sir.
28, we've already mentioned that, it's got to be deleted. Electric vehicle charging points, agree?
Agree.
29, explain to me why that's necessary.
Well, that's a standard condition that we've used over many times to ensure that the landscaping is going to be planted at the correct time to actually be successful and become implemented. And sort of the following conditions then follow on to that, sort of a clause that would replace any that may be lost, damaged, etc.
Would these matters not be covered by anything else that we've already talked about at all?
I think for the planning authority, it provides sort of greater clarity aside from the details that may be in the LEMP or the BP that we discussed earlier.
Or the
So
landscaping reserve matters.
Yeah.
Yeah. Okay. So take 29 and 30 together. The appellants, you haven't raised an issue with them, so
We haven't, no, sir.
okay. Okay. I'll reflect on those if that's okay.
Very good, sir. Yeah, very good.
You'll be glad to hear that I think that's the last one,
Well,
isn't it?
there is one more condition.
There is one more that we talked about,
the
isn't
BNG
there,
condition.
that I've not seen yet. Did you manage to agree a BNG condition?
We have drafted a condition, sir, which I can read out now and then furnish both parties with in a couple of minutes, if that's okay.
Yeah, if you read it out, and it may be that it gets added to the list, and I allow you to, if you like, to discuss it over a few days following the inquiry before you send this completed schedule in to me. Yeah.
Yeah, I haven't seen the wording, but I would hope, on light of yesterday's conversations, that it probably be very similar to a draft that we would consider, which was based on the appeal decision that was brought up yesterday. So
Yeah. Let's just hear it, so I've got in mind what.
Okay, so it says, prior to the commencement of development, details of how the development will demonstrate a minimum of 20% net biodiversity gain shall be submitted to and approved in writing by the local planning authority. Development shall be carried out in accordance with the approved details.
Right.
Sir, on that point, the wording is very similar. What we'd looked at is, rather than prior to commencement of development, it would be prior to the submission of reserved matters as the trigger point to then because quite a bit of it would potentially turn on the technical details of what the reserved matters would be. We feel that that's a more appropriate timing for it, and would be more comfortable with that.
So on that, would it not be more appropriate if it came in with the reserved matters?
I think alongside or
Alongside
prior
the reserved matters? We wouldn't have an objection to that. I mean, that wording prior to the commencement of is taken from the Rainham decision, but based on what the council have just suggested and subject to your review of that, we would be happy if it came in as part of the reserved matters or in tandem with.
Yeah, I think that would be fair. I think it would broadly comply if it came in alongside, wouldn't it?
I think our observation would be that the Rainham case wasn't actually approved, was it? It was the appeal was dismissed, but I think that's a point for consideration. That was all.
Yeah. So I think that I'd be happy with one. I can't say I'd be happy because I would need to sort of fully reflect on it, but I think that that condition is broadly along the lines of what I'd expected you'd come up with. It should be very straightforward, simple condition. I think the point that Mr. Wakefield mentions about it not needed to be done before the reserved matters is a reasonable one, because it's going to rely on them to a degree. Yeah. But again, as I said to you before, if you can review the schedule conditions in light of the comments and points that we've just discussed, and submit an updated schedule to me after the close of the inquiry.
Is there a timescale you'd want that?
I was just thinking about that. It's likely that there's going to need to be some amendments to the 106 as well. So let me just think on that. There's not too much work for you to do there anyway, is there? I think you probably accept. All right, so just bear with me, and then we'll sort that out when we get after the discussion on the obligation. Okay. So unless there's anything else on conditions, I sort of propose a neat short break that will take us through to just after past. Is anything else on conditions that not talked about?
No, sir.
No, sir.
Okay. All right. Well, thank you for that. That concludes the round table on conditions. We'll take a short adjournment and we'll come back at 25 to 12, and we'll have a round table on the planning obligation.
Thanks, sir.
It's 25 to 12 now, so if we can resume, would like to get through the obligation fairly quickly so that we can hopefully hear the closings before needing to break for lunch, ideally, but may
Sorry,
not be
sir.
the case.
Can I interrupt on a housekeeping matter on that point? Just to say that the room isn't available this afternoon. It never was. We've got planning committee.
Yeah.
So we need to be out by about 1:30.
Right, okay, we'll crack on. Is it? Okay. Okay, right. So the obligation, then, the roundtable session on the obligation. So firstly, just an administrative point. I think it refers to the third schedule twice, if you look at the contents page. When actually it should be the fourth schedule. And the fourth schedule, obviously, there's two third schedules, so I'll leave you to that. There's change there that needs to be dealt with. I haven't got any comments on the first schedule or on affordable housing. My comments come back to the point about how the open space is dealt with, and they're my only comments. I haven't got comments on any of the other obligations in there. So I think that if you look at the second schedule of open space provisions, if you look at that, I think it talks about a conservation site, which we are perhaps talking about. The reality is for habitats, you're looking at perhaps a number of sites spread out over the development, but I think conservation site is perhaps okay. It gives the definition of open space land. That includes the conservation site. So I'm sort of happy that it's tied in there. It talks about open space maintenance contribution, and that I'm satisfied that includes the conservation site, which would be all the. Correct me if I'm assuming this to be different. Is that?
Just to clarify, the one that's defined as open space maintenance contribution specifically refers to the maintenance of the local equipped area for play equipment. So that's what that particular figure of 30,038 is to actually cover. Other open space maintenance sums would be calculated in accordance with Table 1 in the event that the land is transferred to the council or another body nominated by the council.
Yep. So Table 1 then, are we satisfied that Table 1 covers everything that would be required for the as specified in the shadow HRA?
Well, we had a brief conversation just before we resumed, and I think we're agreed on. There are a couple of points that we want to put in front of you.
Yep.
One was a suggestion that under the definition of the management company, which incidentally does also again refer there to providing details of funding sources, but that we add in something along the lines that the owner shall promptly provide the council with details of the proposed management company, including but not limited to its memorandum and articles, funding sources, and then add in its responsibilities to maintain the open space land in accordance with the shadow HRA and LEMP.
Yeah,
so we felt that would make matters far more explicit.
Yeah.
And then I think Mr Wakefield was proposing, I think, to cover the contingency over the question of Table 1 and whether those maintenance sums would indeed be adequate for the purposes of maintaining for biodiversity objectives. Perhaps I'll let Mr Wakefield explain that.
Yeah,
point.
that's helpful. It's getting us through this quicker. Yeah.
Yep, so just picking up on that particular point, I think there would be a clause under our suggestion that would be added to effectively pick up on the fact that if the open space calculations based on the provisions set out under the LEMP require an additional sum of money to those contributions set out in Table 1, then that sum of money would need to be paid by the developer as well.
Yeah. Okay.
And obviously leave the solicitors to come to some suitable form of wording as far as that's concerned, but that would be the idea around it.
Right. Well, I agree that those changes are necessary. I've not got that detail before me, so I can't sort of comment on it, but I was looking for you to sort of make those agreements, so that's helpful to the inquiry. If you were to do that, I think that would give me a degree of further, well, of comfort. But obviously I can't, I've got to reserve my judgment until I see an updated version of the agreement.
Sir, on that, would you welcome a further draft version of the Section 106 with those changes included?
I think that would be
review.
sensible before you sort of went away and sort of executed it. Yeah.
Very good.
Yeah. So obviously that you'd be able to do that a lot quicker as well, wouldn't you? So obviously you'd be able to do that a lot quicker as well, wouldn't you?
Yes, indeed.
All right.
Did you want to discuss timeframes?
We may as well, because I haven't really got anything further that I want to comment on the obligation. So how long do you think you would need to make those changes?
It's not to get it signed, just to get it changed.
A week? So if we can come back to you within a week.
Okay. Well, how about the 24th of June?
Very good, sir.
Yeah.
For the revised draft,
Yeah.
and then we will await your feedback
And
on that.
I'll comment on it.
Yeah.
And then, yeah. Okay.
So would you like us to submit the revised schedule of conditions on that same date?
I think I was going to get to that. We're being very progressive today. That's helpful. Yeah, and if I can have the revised draft schedule of conditions by the 24th as well, that would help me, and I can read them both together. Just bear with me a moment. I'm just going to check if there's anything else. Right. Anything else anyone wants to say about the obligation?
No, sir.
No. Okay. I should say both those discussions on the conditions and the obligations were without prejudice to the outcome of the appeal. It's required to understand which would be the obligation should I be minded to approve the application and the conditions that would be necessary. In no way does that mean that I've formed a view on whether or not permission should be granted or not at this stage. Okay. So concludes the roundtable on the obligation and the conditions. So the closing submissions. Are we? We're missing Mr. Leader at the moment. Oh, so I didn't see you. You're hiding at the. Okay. So are you? Do you need a few minutes to prepare?
I'd appreciate 2 moments with Mr. Leader just
Yeah.
to discuss whether there is a legal point between us, because it will just save some printing.
Yeah. How long do you need?
5, 10 minutes. Mine will be being printed as Mr. Leader is doing his. Just so, given there's no members of the public, I'm agnostic. We can read it out in the usual way, or we can hand them up, you read them, and we come back, and I give you the right to reply. It's just it would save you having to hear us read them out. I'm relaxed either way.
Well, there's people viewing online. I think they would benefit from doing it in the usual way. If that's okay.
We'll say if I could have 5 minutes.
Yeah, of course. So we'll adjourn till 12.
Thank you, sir.
first is impact of the scheme on the landscape. An unusual feature of this case is the gulf between the parties' experts on their assessment of the impact of the scheme on landscape character, though, as will be seen, they agree on the harm it would cause to visual amenity. So what's the nature of this disagreement? Mr. Etchell's evidence was that the appeal site is generally pleasant and rural. It affords characterful and attractive views across it to the church tower. It is of high landscape quality. It is also of a high landscape value. That is the product of its scenic quality, heritage interest, the landscape contribution of veteran trees, the recreational value of its footpaths, and views from the appeal site and Windmill Hill towards the Mendips. Consequently, the landscape has high susceptibility and a low capacity to accommodate the development, which would be out of character with existing landscape and the pattern of built development along Front Street. And the result would be a high adverse impact on the local landscape of the site and its immediate surrounds in year 1, reducing to a high to moderate adverse effect after around year 15. Locally significant harm to the setting of the AONB arising from the erosion of views from the appeal site and across the site from Windmill Hill, and a high adverse effect on visual amenity of users of footpaths across the site and across Windmill Hill. Moderate to high adverse visual effects to pedestrians using Church Lane and the use of local roads, and moderate adverse effects viewed from properties to south and west. Now, Mr. Cook disagrees. He contends the site has a strong edge of settlement character, urban fringe or peri-urban in nature. He describes it as framed by existing housing and school campus. He describes it low value, low susceptibility and sensitivity. He places great stress on the site's use for horticulture and the general residential character of Churchill as a settlement. He sees no material difference in the character of Old Churchill and other parts of Churchill, such as Churchill Gate and Langford. He accepts the site would see some considerable change from pastoral fields, yet he argues the distinctive rural settled character of the area would remain unchanged with the proposed scheme in place, which would be in keeping with the settlement and the general character of the valley. I think that should say area, actually. I do apologise how the word valley got in there, I don't know. It's area. So, who is right? There are 6 reasons for preferring Mr. Etchell's assessment. First of all, the high sensitivity of the site and its immediate surroundings is supported by Wardle Armstrong's expert and independent analysis of landscape sensitivity to residential development, which was prepared in 2018, and thus without regard to the appellant's proposals, as part of the evidence base of the Joint Spatial Plan. The quality, value and sensitivity is corroborated by expert landscape assessments commissioned by the Parish Council to support the development of the neighbourhood plan. Thirdly, Mr. Etchell's assessment of the rural and scenic quality of the land in the immediate vicinity of the appeal site is validated by the decisions of your colleagues, Inspectors Cridland, Wyborn, Chandler, Pope and Jones. Fourth, the North Somerset Landscape Character Area SPD assesses the overall strength of character of the J2 River Yeo Rolling Valley farmland as moderate and in good condition. Mr. Cook accepted the site reflects that character, except that it is used for horticulture. But that was a bad point. A particular feature of J2 is that this rural pastoral landscape is used for grazing horses, or if you wish, horticulture. Fifth, Pegasus's own LVIA states the susceptibility of J2 is considered to be medium due to the degree of existing enclosure provided by the site boundary vegetation and built form within Churchill. A medium to high value and medium susceptibility translates into medium to high sensitivity. I ought to put in brackets there, CF Mr. Cook, close brackets. Sixth, Mr Cook tied the urban fringe quality of the appeal site to views of houses along Front Street of the school, arguing the site is contained by development on three sides. Ironically, that narrative was directly contradicted by the appellant's heritage evidence. Mr Sutton repeatedly asserted only three houses can be seen from the appeal site. The same point was put several times to Dr Hudson Macaulay. There's no development to the north or east. To the west, the school is screened by trees and hedges. In short, if I may add a sentence, to say the site is contained by development is nonsense. Viewing the evidence as a whole, Mr Cook's negative assessment of the baseline is an outlier. That invalidates his conclusion the scheme would have a neutral impact on landscape character. Mr Ettrels's evidence that the overall landscape effects would be high adverse should be preferred for 7 reasons. First, as Mr Cook concedes, in line with Mr Ettrels's evidence, the site would see some considerable change from pastoral fields. That changes 3 specific components. A, the rural pastoral character of the site would literally be obliterated and replaced by a suburban housing estate. By definition, that is at variance with the pattern of the local landscape. Specifically, the appellant proposes to introduce a new north-south axis in depth beyond the western edge of the old village and to the north of the rear of properties that line the northern side of Front Street. It would appear as a large-scale, relatively uniform, low-density suburban addition to an historic village. That would appear entirely alien. Old Churchill has a strong linear form arranged along an east-west axis. The village has developed gradually, organically. Its grain is dense. The built form exhibits a great range of styles, materials and detailing. The drive and the orchard provide no kind of precedent. Each is a much smaller infill development of Front Street that maintains the village's historic linear form and character. And B, attractive landscape features will be eroded or obscured. The veteran trees, the oak, the sycamore, would no longer be seen in a pastoral landscape. Views of the church from within the site are likely to be blocked, and insofar as they can be preserved, they will be urbanised. Views south and west from Windmill Hill across the appeal site towards St John's Church will cease to be a sweep of open pastoral land to the south of Churchill, forming an attractive backcloth to the historic village, nestling along Front Street. That view will be expunged by the walls and roofs of a housing estate. There would be a similar adverse impact on views to the south towards the Mendips AONB. And so where I said 4 lines up, there will cease to be a sweep of open pastoral land to the south of Church. That should be the north. I do beg your pardon. And then C, the tranquility and pastoral quality of footpaths across the appeal site will be changed to a walk through the hubbub of a housing estate. Mr Cook's assessment of the landscape effects, thirdly, is also inconsistent with his opinion that the scheme would cause major and moderate harm to visual amenity. Mr Ettrels's evidence that the assessment of these 2 components do not sit easily together is plainly right. It is no answer for Mr Cook to argue, but you can see the school which detracts from the value of the landscape. In fact, the school is barely visible from most of the appeal site, and even from Windmill Hill it is well contained by screen planting of trees and hedgerows. And Mr Cook's contention that the impact of the scheme would be reduced because the site is bounded on 3 sides by existing development is simply wrong, as I've already explained. Next, the urbanisation of the landscape would be clearly visible from the surrounding area. Direct views into the site would be afforded from accesses as proposed along Church Lane and Front Street. The first floors and roofs of houses would be seen above the hedgerow fronting Church Lane. There would also be clear views into the site from Hilliers Lane and from the western end of Front Street. The creeping urbanisation of the landscape would be especially obvious from Windmill Hill. That would harm views towards the Mendips AONB from one of the few vantage points that affords an elevated and panoramic view towards the south in the vicinity of Churchill. The importance of views towards the Mendips had not been appreciated by the appellant, which was unaware of the advice contained in the PPG, paragraph ID 842. The appellant belatedly sought to rely on the parish council's landscape evidence to argue it does not identify the view from Windmill Hill as important. That is a bad point. The views identified by that document are plainly indicated diagrammatically on a small-scale plan, and this point was not put in any event to Ms. Retchells. Next, the development of the appeal site would jar conspicuously with the evolution of Churchill's historic landscape and settlement pattern. The appeal site separates the church from the old village. Mr. Cook agreed that this imparts a distinctiveness to Churchill which contributes to its particular identity and sense of place. That important element of distinctiveness and local identity would be lost if the appeal site is infilled by housing. Seventh and finally, it would be surprising if the impact on the landscape of this scheme of 62 homes were to be less or less objectionable than much smaller proposals adjacent to the appeal site along Front Street, reported on by Inspectors Crickland, Wyborn, Chandler, Pope and Jones. Yet that is what is urged upon you by Mr. Cook. Accordingly, in respect to this first issue, you are invited to conclude the appeal proposals would cause substantial harm to the landscape. Moving on to the impact of the scheme on designated heritage assets. Mr. Sutton gave evidence with a chutzpah that was notable even by the standards of public inquiries. It is most unusual in matters of expert judgment for two well-qualified witnesses to be poles apart. Mr. Sutton found absolutely no harm at all would be caused to either the setting and significance of the Grade 1 listed St. John's Church or the appearance and character of the Churchill Conservation Area. Dr. Hudson Macaulay's assessment was more measured. She found less than substantial harm would be caused to both assets. You are invited to accept Dr. Hudson Macaulay's evidence, taking each asset in turn. First of all, the impact on the setting and significance of St. John's Church. Mr. Sutton agreed that the church derives significance from its setting in four ways. First of all, it reveals and permits the experience of its monumental and wayfinder value. Second, it reveals the aesthetic quality of the church and the group, which is the cottage and Churchill Court, together with the church. Third, it provides evidence of the village's historic pattern of development. And fourth, it contributes to the group value with the cottage and Churchill Court, which has functional significance. If I mentioned that a sentence, you will recall at the start of Mr. Sutton's cross-examination, I agreed each of those 4 points with him. It is common ground that the appeal site is part of the setting of the church. Setting is the surroundings in which an asset is experienced. The importance of setting lies in what it contributes to significance of the heritage asset, or the ability to appreciate that significance. Taking each aspect of significance in turn, and the church as a monument and wayfinder first, Mr. Sutton agreed church towers would have been very expensive structures. They reflect communal value, and the raison d'etre is that they are designed to be seen. That being so, the monumental significance of St. John's Church is derived from its visibility in the landscape. However, Mr. Sutton's written evidence on this point is clear. The path through the appeal site is, to quote, one of the few locations in the wider setting of the church where the tower can be glimpsed, forming its role as a landmark or wayfinder. During his examination in chief, he sought to escape this difficulty by arguing the church is a landmark viewed from the north and west. However, the views that contribute most to the monumentality are those described in his evidence, that is, views from the village. The development will obstruct, erode and change the character of the church from the footpaths across the appeal site and from Front Street at Hilliers Lane. That will harm its significance as a monument in the rural landscape. Next, the church's aesthetic quality. Mr. Sutton accepted the wider setting of the church facilitates the appreciation of its fine architectural qualities. Those qualities may be appreciated from within the church. However, the church's beauty is derived in part from its fortuitous relationship with the cottage and the pastoral landscape it sits in. that is best appreciated from the middle distance of the appeal site. The obstruction and suburbanisation of that composition will erode the opportunity to appreciate the aesthetic dimension of the church's significance. That is a source of less than substantial harm. Next, evidence of the village's historic pattern of development. The historic environmental record provides evidence of a deserted medieval village to the north of the church. Mr. Sutton agreed that the separation of the church from the old village of Churchill evidences a distinct phase of its historic development. He agreed it is relatively unusual for a parish church to be separated from the village it serves. He also accepted that the footpaths across the appeal site tie the old village to the church and would have been used for centuries by worshippers. The open pastoral quality of the appeal site thus evidences and maintains the unusual pattern of development of Churchill. If the appeal is allowed, the church would be absorbed into the village, whilst it would, for now at least, continue to sit on the edge of the village. The historic pattern of development of Churchill would be less legible. The erosion of that evidential value constitutes further harm to the setting and significance of the church. Finally, and with some caution, harm to the church's contribution to group value. The group value of the church viewed from the cottage in Churchill Court, viewed with the cottage in Churchill Court, is identified by Mr. Sutton as a component of its functional significance. Mr. Sutton agreed that as a result it is likely that the development of the appeal site would lead to some loss of the ability to appreciate this element of significance. To be fair, Dr. Hudson Macaulay did not raise this point. Mr. Sutton did, though. He was questioned, his answers are material, and they indicate an additional adverse impact on an aspect of the setting and significance of the church. Coming next to Mr. Sutton's general traverse and false premise of his conclusion of no harm. Faced with the obvious harm the scheme would cause to all four facets of setting and significance, Mr. Sutton's general refrain was, but you will still be able to appreciate the monumental aesthetic, evidential and group value of the asset. That is right. Those qualities will not be totally destroyed. However, the fundamental flaw in Mr. Sutton's case is that it proceeds on the false premise total destruction of each is a necessary precondition of less than substantial harm to setting and significance. That is obviously wrong. To the extent setting is preserved and allows each kind of significance to continue to be appreciated, that will reduce the degree of harm that is caused by the scheme. However, having regard to the extent to which the appeal site affords some of the few opportunities to appreciate key aspects of the church's significance, you are invited to accept Dr. Hudson Macaulay's assessment that the scheme would cause less than substantial harm to the significance of the Grade 1 listed church. Next, impact on the conservation area. Part of the appeal site lies within the Churchill conservation area, the remainder is part of its setting. In that context, it is important to note that according to Section 69 of the 1990 Act, land may only be included in a conservation area if it is an area or part of an area of special architectural or historic interest, the character and appearance of which it is desirable to preserve. Therefore, the starting point is that land forming part of the appeal site inside the conservation area meets that test, and that it is desirable to preserve or enhance its appearance. The appellant contests this by reference to paragraph 207 of the framework. However, the framework cannot be used to construe the 1990 Act, and in order to read the former consistently with the latter without undermining Parliament's plain intent, secure the protection of areas for the reasons and to the extent determined by the authority that designates them, the reference to not all elements of the conservation area should be interpreted to mean land which is plainly and obviously at odds with the purposes for which a conservation area is expressed to be designated when that protection is conferred under Section 692 of the Act. If I may add a sentence there, sir, to give you an example of what I'm talking about. It may be that within a conservation area there would be a piece of underused, derelict or vacant land. Fair enough. It would be obvious that that land could not have been designated under 69(1) consistent with the objects of designation of the designating authority. That would be caught by paragraph 207. But if you've got a piece of land, such as that which we're contesting in Churchill, which plainly, when designated, was consistent with the objects of the authority, you can't place that within the category that is encapsulated by paragraph 207. So if I could pick up after footnote 21 in paragraph 17. Mr. Sutton contends that approach is wrong. However, his argument can only succeed if the description contained in the designation document of what is of special interest, the character and appearance of which it is desirable to preserve or enhance, is ignored. For the reasons given by Dr. Hudson Macaulay, open land to the north of Front Street does contribute to the special historic character of the conservation area. Therefore, it must be preserved or enhanced. Now, Dr. Hudson Macaulay concludes the urbanisation of the conservation area to the rear of Front Street would harm its historic appearance and character. Mr. Sutton disagrees. However, Dr. Hudson Macaulay's approach is to be preferred, being validated by the recent decision of your colleague Inspector James in respect of adjacent land at Barrowfield on Front Street. In the light of that decision, the key point is that the considerably greater scale of the appeal proposals would be visible to the same extent from Front Street and would have a markedly greater impact viewed from Church Lane, footpaths across the appeal site, and from Windmill Hill. As in that decision, the harm would constitute a clear reason for the refusal of planning permission. Similar arguments apply to the impact of the scheme on the setting of the conservation area. The urbanisation of the countryside immediately to the north of the conservation area would reduce the potential to appreciate the historic rural character of the old village from footpaths across the appeal site and degrade views obtained from Windmill Hill. The harm to the character and appearance of the conservation area and its setting would also be less substantial, but it should be accorded great weight. That is also a clear reason for refusing planning permission. So next, moving to housing land supply. The Council cannot demonstrate a 5-year supply of land for housing. The shortfall is material for the purpose of deciding whether the most important policies for determination of the appeal are out of date. However, Mr. Wakefield agreed the extent of the shortfall is not itself a key consideration in this case. It bears on the weight to be attributed to the Council's objection to the scheme's impact on landscape and designated heritage assets. That is a matter of planning judgment having regard to the broad magnitude of the shortfall, how long it is likely to persist, what the local planning authority is doing to reduce it, and how much of it the development will meet. Neither Mr. Tiley nor Mr. Wakefield suggested any other matter is relevant in this case, taking each in turn. The alleged shortfall ranged from about 2.95 years to 4.9 years. The difference is likely to sit somewhere in the middle. That is so having regard to the fact the housing delivery test has improved consistently for the last 4 years, with the result the Council is now in 2022 a 5% buffer authority. In the terms of the framework, that means there is not deemed to have been significant under-delivery of land over the last 3 years, nor is a 20% buffer now required to improve the prospect of achieving the planned supply. The significance of that result is that it has been achieved against the background of inspectors assessing supply generally in excess of 4 years. And if I could just add there, sir, I've given you the reference to Mr. Tiley's proof. Have a look at it. He records lots of decisions, and you will see a constant pattern emerge. Furthermore, that improvement has been achieved even though the standard method has inflated need by around 400 dwellings per annum, that is compared with the core strategy policy CS13, The delivery of affordable housing broadly meets the requirement of CS60. Viewed fairly, the picture is therefore one of improvement, not stagnation or deterioration. Mr. Tiley and Mr. Wakefield both conceded the new local plan that is under preparation will correct the shortfall, or else it will not be found sound. Mr. Wakefield acknowledged the LDS indicates the plan is scheduled to be adopted in 19 months. He has no evidence it is not on track. Moreover, the Council is not starting from scratch. It already possesses a comprehensive evidence base which was collated to support the joint special plan. It has completed the challenges and choices consultation. If I could just add there, sir, other councils call that issues and options. And published the preferred options version of the plan. That is concrete evidence of progress. There is every prospect that it will be adopted and the shortfall corrected in around 19 months. The Council is also granting planning permission under the flexibility afforded by policies CS 28, 31 and 32. A case in point is Deanhurst Road in Churchill, an outline consent granted this year for up to 25 homes, which was dealt with by Mr. Stevenson. That flexibility will continue to yield housing sites in sustainable locations. Mr. Tiley has not investigated what contribution has been made by this class of sites since 2017. His list at paragraph 517, footnote 17, was agreed to be non-exhaustive. Thus, it is by no means clear that the extent of the shortfall will persist at current levels until it is superseded and eradicated by the new local plan in December 2023. Mr. Tiley further agreed that if the appeal is allowed, it will contribute towards meeting only 2% of the shortfall based on the Council's assessment. The figure is much lower based on his own assessment. Applying the test specified by Lord Justice Lindblom, that weighs against the grant of planning permission. In the circumstances, and consistent with numerous other decisions in North Somerset in recent years, you are invited to conclude that the weight which should be given to the harm caused to the landscape and designated heritage assets should not be reduced materially by the shortfall in the housing land supply. So come to the planning balance. The appellant admits the scheme conflicts with policies CS32 and CS33 and that it does not accord with the development plan read as a whole. The appellant does not admit conflict with CS10, DM10 or the landscape component of CS32. That issue is said to be academic. Mr. Stevenson was right to disagree with that assertion, I should say, in re-examination. As a matter of law, a decision maker must establish whether a scheme complies with the plan as a whole. That requires the consideration of each of the main policies. Otherwise, it is impossible to understand the nature and extent of conflict with the plan or to determine the weight that should be attached to it. In this case, that exercise is especially important. Conflict with CS32 is only admitted insofar as the scheme exceeds limits on the permitted scale of development, and any conflict with CS5, DM3, DM4 and DM10 is denied. In respect to CS5, DM10 and CS32, it is no answer to argue that landscape harm is accounted for as another material consideration. That would avoid the priority afforded to matters protected by the development plan. It also begs the question, if the issue of conflict with CS5, DM10 and aspects of CS32 is merely academic, why have the appellant's witnesses strained to apply the policies to exclude visual impact on the landscape? The answer can only be that the appellant recognises the critical importance of this issue, which is given extra force by those policies. So turning to those policies, the appellant's approach is demonstrably wrong. Mr. Wakefield agreed no other appellant has interpreted the policies as he has done, nor has any inspector done so. That is unsurprising. It would be absurd to interpret a policy which is intended to control the visual impact of development on landscape to exclude visual impact. Visual impact is caught by those policies. Harm to the appearance of the landscape is admitted. Therefore, the scheme conflicts with each of those policies. For the reasons given by Dr. Hudson Corley, the scheme will not protect or enhance St. John's Church or Churchill Conservation Area. Consequently, it also conflicts with policies DM3 and DM4. In short, the scheme causes comprehensive conflict with the development plan. In accordance with section 38(6) and 72 of the Principal Acts, planning permission should therefore be refused unless that conflict is outweighed by other material considerations. So coming to those, market and affordable housing first, the supply of each would be the principal benefit of the scheme. Mr Stevenson accords that significant weight, and so should you. As to biodiversity net gain, the Council accepts in principle the scheme can deliver BNG. However, the importance attached to this benefit should be tempered. Firstly, by the appellant's failure to identify it in the statement of case. Secondly, Mr Wakefield's retreat from a firm claim it will secure 44% net gain. And thirdly, the absence of a scheme that will deliver 20% net gain. The appellant cannot sensibly rely on the weight attached to BNG at Pump Lane in Raynham. That weighting turned on the particular facts, which involved substantial improvement of an orchard which had been significantly degraded. There is no evidence that this case is comparable in that or any other respect. BNG therefore attracts only some, I'd suggest moderate weight. As to other benefits, the other benefits claimed by the appellant were also omitted from its statement of case. That is evidence of their relative lack of importance compared with the provision of housing, which you will recall was mentioned. They are material, but not determinative. Each should be afforded the more limited weight specified by Mr Stevenson in his proof of evidence, and so which you have a note of. So turn to paragraph 11D of the framework. Absent of 5 years housing land supply, the main policies for determining the appeal are deemed to be out of date. However, the first paragraph of that, paragraph 11D, is engaged by the less than substantial harm that is caused to two designated heritage assets, one of which is grade 1 listed. That harm must be accorded great weight after taking account of the supply of up to 62 homes and other considerations which do not even merit a mention in the appellant's statement of case. That provides a clear reason for refusing planning permission. Alternatively, the adverse impact of the scheme on the landscape, including the setting of the AONB and on designated heritage assets, significantly and demonstrably outweigh the scheme's benefits when assessed against the policies of the framework taken as a whole. So in the circumstances, the application of the tilted balance ought not to override the statutory priority according to the development plan. And in conclusion, the crux of this case is whether the need to identify more land for housing overrides the statutory priority that is afforded to the development plan in the most sensitive location at the edge of historic Churchill. It should not. The harm that would be caused to an attractive landscape, the setting of the AONB, a recently designated conservation area, and a grade 1 listed church is obvious. The scheme cannot sensibly be thought to deliver sustainable development. To contend otherwise flies in the face of a series of recent decisions that validate the protection of barrier fields. It was and is open to the appellant to make a policy compliant application, or it could still pursue an allocation through the new local plan. That it chose instead to bank on proving the absence of a 5 years supply to develop the whole was unwise. That is not always a trump card. For the reasons I have set out, it is not in this case. Therefore, the Council invites you to determine the scheme in accordance with the development plan and dismiss the appeal. So I hope that was clear. If there's anything I need to deal with, I'll be happy to do so. Otherwise, those are my submissions.
Thank you. Mr Garvey, closing submissions for the appellant, please. Thank you.
So just before I begin, can I, it's on my mind, can I ask the council to email a copy of their closing submissions to us, just so we've got a copy before I forget? Thank you. So I'm going to begin by making a few preliminary observations of my learned friend's closing, and then I'll go into mine. As I go through mine, there's a few points where, again, I'll refer to my learned friend, but there aren't many references. So just beginning with my learned friend's closing, if I can invite you just to look at paragraph 15, if you would, please, sir. So the point being made by the council here is that there is a group value to the other heritage assets surrounding the church, and therefore impacts on those assets has a consequent impact on the church. We dealt with that as an intervention during Mr. Sutton's cross-examination. The council agreed there is no harm to those other heritage assets, and as Mr. Sutton put it, is a backdoor way to try and creep in other heritage assets. I say, sir, it's not a proper point to be put in closing. So my next observation is about paragraph 16 of the council's closing. It said, a few sentences in, the fundamental flaw in Mr. Sutton's case is that it proceeds on the false premise total destruction of each is a necessary precondition of less than substantial harm to setting and significance. So my phone was lighting up during the closing from Mr. Sutton. I won't share what he said, but say for this, none of those points were put to Mr. Sutton. Mr. Sutton does not say anything of the sort in any of his evidence, either oral or written, and it was not suggested to Mr. Sutton that that's what is required. It is obvious that a heritage expert of Mr. Sutton's calibre and experience is not going to suggest that anything less than total destruction can be ignored. So the next point is about paragraph 17, if you would, sir. And 17 is a long paragraph. It goes on to the second page. It suggested that Mr. Sutton's arguments can only succeed if the description contained in the designation document of what is of special interest is ignored. Again, sir, none of those points were put to Mr. Sutton where we went through the Conservation Area Management Plan, which is what I assume it's referring to as the designation document, and it was being drawn, well, Mr. Sutton, this is what it says, you must be taking a different view. That sort of analysis was not undertaken. Again, sir, not proper points to put in closing. The next point, sir, paragraph 20, if you would. The third sentence, it said, however, Mr. Wakefield agreed the extent of the shortfall is not itself a key consideration in this case. So that doesn't align with my memory of what was said. I invite you to review your notes as to whether Mr. Wakefield ever agreed that. So that's it for now. There'll be one or two points where I diverge from my closing, but that's it for now. So if you're content, I'll jump in. Thank you. Yeah. So, sir, as with the opening submissions, these closing submissions address the main issues from your case management conference. There are a few headline points to make at the outset. A, it is acknowledged that the Council do not have a 5-year housing land supply, resulting in the most important policies for determining the appeal being out of date, namely the policies and the reason for refusal. B, it is common ground that the Council's development plan strategy has failed. C, the Council will have a planned period shortfall, even assuming their assumptions on housing delivery are correct, which they blatantly are not. D, the Council have not had a 5-year supply for 8 years, and there is no trajectory or evidence to indicate when this will be remedied. E, it is agreed that substantial weight should be afforded to the provision of both market and affordable housing. F, it is agreed that significant weight should be afforded to the economic benefits. G, harm to the A1B is, on the Council's case, not a reason in and of itself to justify the refusal of planning permission, and is essentially just views towards the A1B from its setting which need to be taken into account as a material consideration, given views from the A1B looking out are negligible on the Council's case. H, any impact to the character and appearance of the area is highly localised in the context of the Council accept that they need to deliver greenfield sites outside of settlement boundaries in order to restore a 5-year supply. I, the Council view on harm to the conservation area and St John's Church is reliant on the appeal site being a historic, fossilised late medieval enclosed field. However, when one scrutinises the issue, it becomes clear that the site is patently not a special fossilised landscape, and finally, that the appellant has committed themselves to delivering at least 20% BNG in the context that there is an undisputed evidence that the proposal can achieve up to 44.13 BNG. The effect on the proposal on the character and appearance of the area, I've split up this first main issue so into each of the area and then each of the separate assets. So in terms of designations, it is agreed that the site is not subject to any landscape designations, nor is it a valued landscape in the context of the framework, paragraph 17A. The framework recognises the need to protect and enhance valued landscapes where it affords a lower level of protection to undesignated non-valued greenfield sites in the countryside, whereby there is a lesser requirement to simply recognise the intrinsic character and beauty of the countryside as opposed to protect and enhance. On Mr Etchell's evidence, there will be a negligible effect on the national character area and only a slight adverse effect after mitigation on the local landscape area. The highly localised impacts on an open field. Mr Etchell acknowledged that the harmful impacts associated with the site are highly localised. This was best demonstrated by his figure 3. However, even though this shows a tightly drawn visual envelope around the site, Mr Cook explained how this visual envelope was over-exaggerated, given that it included, amongst other things, views from over the road from the school, views from along Windmill Hill towards Churchill, from further along Front Street towards the village core, and from within the courtyard of the church. Your site visit will demonstrate that such views either do not exist or will not be materially impacted. Thus, even though Mr Etchell draws the zone of influence narrowly, properly drawn, it is even more localised. This point is particularly relevant when one considers that Mrs Richards accepted the council are reliant on greenfield sites outside of settlement boundaries to try and restore their housing supply. Indeed, such sites already form a component of their existing supply. Further, Mr Stevenson expressed his view that is, quote, kind of inevitable, having some landscape harm putting housing in a greenfield site. Pursuing this line of reasoning, it follows that it is inevitably the case that sites will need to be granted in this district on greenfield sites that it will attract some visual harm. Any such site will inevitably have localised views both within and in the immediate vicinity of the site. Indeed, even the most highly screened greenfield sites will inevitably provide this degree of harm. Thus, it is surprising that one of the central features of Mr Etchell's evidence relies on this being an open field. Indeed, in respect to the landscape elements he values, he concedes most points, but maintains that this low-quality pastoral land was still a prominent landscape element. Again, the same could be said of any greenfield site. Furthermore, Mr Etchell sought to place emphasis in his views on the landscape features of the site and its surroundings that, quote, the open fields of the site would be permanently lost and, another quote, the new houses may become less visible over time in some views, but they would still be there and the open land would still have been lost. Again, one could copy this text into a proof of evidence pertaining to any generic greenfield site across the country. Accordingly, for the council to seek to highlight this being an open field with localised views as being a central feature of their case on character and appearance negates the reality that the loss of such fields is inevitable. Indeed, viewed in context, even if you agree that this does give rise to some harm to character and appearance, that harm needs to be understood in the context that some harm is unavoidable. Mr Cook, the outlier. The other big point to take from the highly localised visual envelope around the site is that this negates the council's reliance on other sensitivity studies. At the outset of the inquiry, sir, you were presented with a table which sought to compare the various findings about the site on landscape and visual assessments. It was introduced to superficially present the view that Mr Cook is the outlier in his judgments towards the site. However, when one properly scrutinises the comparisons, they did not hold up. The council introduced the Paris sensitivity study to the inquiry. This is not a public document until, ironically, the inquiry, and has not been consulted upon. That naturally reduces the weight to be afforded to it, but if one actually looks at the area that was assessed, i.e. CH1 at figure 8, one can see that the appeal site is included in a much larger area of land that encompasses part of the A&B and the school, amongst other places. These are places that have no commonality, and the land use impacts associated with them are fundamentally different. Indeed, the sensitivity of an existing school outside the A&B cannot be compared to undeveloped land within the A&B itself in sensitivity terms. Given that the appeal site's envelope is so highly localised, plainly pooling it in with a number of other sites that have entirely different impacts and designations to form an overall view cannot be compared with Mr. Cook's finer grain analysis of the site. The same exact point can be made about the Ward Armstrong report. Moreover, to the extent that the Ward Armstrong does address land to the north of Area 3, that is addressing an area of rising ground, which cannot be taken to apply to the appeal site. Thus, the highly localised envelope of the site necessarily means that broad assessments about much larger parcels of land cannot be disentangled to make conclusions about the site itself. Rather, the fine-grained analysis Mr. Cook provides us is what is ultimately required. To try and suggest that he is in conflict with a number of other assessments is a poor comparison. Methodology. So, as Mr. Etchell's agreed at the outset of his cross-examination, there are no methodological differences of opinion for you to resolve in landscape. The Council accept that the appeal is supported by an LVIA that is consistent with Glivia. Rather, the differences relate to matters of judgment that only can be resolved through your site visits. It was suggested to Mr. Cook that notwithstanding there are no methodological criticisms of the appellant, there was a lack of transparency in how he has set out his findings. However, when one reads his proof, it is clear that he assesses susceptibility, magnitude of change, effects and impact in respect to each landscape element in the same essential manner in which Mr. Etchell did. He simply did not collate those findings into a table for which there is no requirement to do so in Glivia. Thus, ultimately, there is no methodological issue in the approach to the landscape, nor can the appellant be criticised for not having assessed something that they ought to. Rather, there is simply, classically, a difference of judgment. A&B. Mr. Stevenson agreed that the harm to the A&B on the Council's case was not a reason of itself to warrant the refusal of Planning Commission. This was reflected in the fact that policy DM11 does not constitute one of the most important policies for determining the application, nor a policy in the reason for refusal, and two, that the Council did not allege any harm to the A&B in their reason for refusal. As regards the view from the A&B, the Council conceded during the inquiry that the impact would be negligible. The appellant's case is that there is no appreciable impact on views from the A&B, given that, at most, all that will be perceived is the view of a few rooftops in the context of other existing buildings from glimpsed, heavily filtered views. Mr. Etchell essentially agreed. Any such slight impact does not give rise to any policy conflict or engage the protection to the A&B and the MPPF. Indeed, the planning system is concerned with material impacts, not negligible, i.e. by definition non-material impacts. As regards views towards the A&B, it is common ground that the site is within the setting of the A&B. However, the setting of the A&B covers a vast area. The MPPF does not protect the views towards the A&Bs in the same way as it protects views from it. Thus, the great weight to be afforded to conserving and enhancing the A&B is reserved for land within it. Indeed, that is consistent with the Stroud judgment, which I'll take as read. It's the same quote from the opening. And I'll jump to paragraph 22. Thus, in Stroud, the court was acknowledging that the restrictive policies that are engaged in respect to the A&B are reserved for views from the A&B, as to extend this policy protection to views towards the A&B would give very widespread protection beyond what was envisaged by the MPPF. Indeed, in this instance, the setting of the designation is vast or covers a very large area, per Mr. Etchell. The A&B is itself vast, covering 198 square kilometres. Extending the policy protection to anywhere where the A&B can be appreciably seen, and thus its setting, would extend this protection in a manner that is not envisaged by the framework as recognised in Stroud. Rather, the planning practice guidance requires that development within the setting of the A&B will need sensitive handling that takes these potential impacts into account. That is consistent with the appellant's case, namely that one takes the impact into account, but that this does not engage the same protection to land within the A&B. Moreover, as Mr. Stevens acknowledged, it does not trigger the exceptional circumstances test within policy DM11. As Mr. Cook maintained, the fact that the site has been in the setting of the A&B informed his conclusions about the extent of visual harm. Windmill Hill. The appellant acknowledges that views towards the appeal site from the public right-of-way leading from Windmill Hill are the most sensitive across the appeal site. However, a few points need to be noted about this view. The first point is that this is not an identified view or vista in Churchill. Indeed, the parish landscape sensitivity study provides the only document before the inquiry that identifies key vistas and views providing important setting to village and sense of place. This demonstrates what views are considered to be important, and one will note that they do not include any views from Windmill Hill across the appeal site or towards the AONB. Whilst views from Windmill Hill elsewhere in Churchill towards the AONB are shown, none of them are associated with the appeal site, nor are they within the highly localised area of influence identified by Mr. Etchell. That underscores the point that Mr. Cook's point that the view from Windmill Hill is not one of such sensitivity as Mr. Etchell identifies. Indeed, in this respect, Mr. Etchell is the outlier. Just pausing there one moment. It's said by my learned friend that I didn't put that figure from the parish landscape sensitivity study to Mr. Etchell. That's, of course, true. So we were handed that sensitivity study mere hours before Mr. Etchell took the stand. We explored it properly with Mr. Cook in evidence in chief. Mr. Cook wasn't challenged on it. So that point cuts both ways. It's paragraph 26. The second point is that the experience of the site from Windmill Hill needs to be seen in context. As Mr. Etchell accepted, owing to the plateau and elevated ground of Windmill Hill, when one traverses the public right-of-way towards the appeal site, one actually sees the settlement of Churchill prior to seeing the appeal site. As Mr. Cook said, someone expects to see the settlement and housing at this point. Thus, one is seeing the site at all times from this location in the context of the settlement and surrounding housing. Thirdly, the experience of someone walking this route with the view of the appeal site is short-lived and again highly localised given its proximity to the site. Mr. Cook does acknowledge harm in visual terms from this location, but the harm must be tempered given the context above. Landscape elements. It was accepted that many of the landscape elements of the site will be improved. Indeed, Mr. Etchell agreed that the appeal proposal would offer an improvement with trees and hedges. Indeed, Mr. Etchell described them, the appeal scheme as a winner in both respects. Moreover, the topography of the site is unaffected. The grassland is improved and there is an opportunity for further recreational opportunities through the creation of public open space and water features. Nevertheless, Mr. Etchell maintained that there would still be the loss of an open field and harm to veteran trees. As regards the veteran trees, there is no contention that the root protection of the trees will not be protected. Rather, Mr. Etchell seeks to argue that they will be harmed as discrete landscape features. That does not invoke the policy protection afforded to veteran trees. Mr. Cook explained how the illustrative master plan had shown deference to these trees through making them into features of the site, and the ability to provide access to the trees in a safe manner in close proximity was a positive of the proposal. That is unlike the situation today where only one of the veteran trees can be approached on one side of the public right-of-way. As regards the open field as being a landscape element, there was no suggestion that the pastoral land was of any particular quality, or at least no evidence supporting that. It is again another way for the council to rely on their theme that the site is an undeveloped greenfield site. Landscape character. Mr. Cook acknowledged that the character of the immediate site would fundamentally change through the development proposal. Indeed, the site is a pastoral field which would become a residential development with a strong green infrastructure. Mr. Cook acknowledged that this change was commensurate and inevitable with any greenfield development. That chimes with Mr. Stevens' assessment of harm that the council will inevitably face through the release of greenfield sites in order to meet its housing requirement. The appellant does not shy away from the fact that this will carry some harm to the landscape in visual terms. However, Mr. Cook argues that there is no harm to the wider landscape character, that being distinct to visual harm, as Mr. Etchell agrees with in principle in his proof. There is some dispute about the extent to which the site is rural. Mr. Cook regards the surrounding built form as providing the site with an edge of settlement or semi-rural or peri-rural feel, a peri-urban feel, sorry. Mr. Etchell, in contrast, simply sees the site as being rural in character, and owing to it being heavily screened, one does not experience the relationship with the settlement. You will note, sir, how those points are difficult to reconcile with the focus in the heritage evidence on the site having a relationship with the built form of the settlement. Mr. Etchell conceded that the harm from distinct views, including from the AONB, was negligible, owing to the change to the site only appearing to be incremental when set against the surrounding development and rooftops. That raises the obvious point that, if the residential development of the site would only introduce an incremental change as compared with its surroundings, it is difficult to understand how the landscape character can be said to be so fundamentally harmed. The only way in which this point can be properly rebutted is for the council to rely on the views immediately around the site and suggest that this is where the change to the character may occur. However stated, Mr. Stephen acknowledged that such changes and associated harms were an inevitable harm the council would need to contend with to restore a 5-year supply. Residential amenity, Mr. Etchell sought to argue at one stage that there would be harm to several views from the second floor windows from private properties. However, the council accepted that this would not give rise to harm to residential amenity. There is plainly no right to a view from a private receptor point. Moreover, when pushed on this point, Mr. Etchell accepted that any alleged harm would ultimately not adversely impact upon the ability of these residents to enjoy their property. Thus, the alleged impacts cannot sensibly be regarded as being material in this context. The conservation area. The council alleged that there is moderate, less than substantial harm to the Churchill conservation area, whereas the appellant says that there is no such harm. As I said in opening, the council's essential point in respect to the conservation area is that there will be housing in an open field, and this must necessarily harm the conservation area. However, the council did not properly examine what the historical significance of the conservation area was and what contribution the site currently makes towards it. Dr. Hudson Macaulay proposed that there are essentially 4 ways in which the significance of the conservation area can be appreciated from the appeal site, namely, point 1, that the illustrative views of built form from along Front Street, namely the views from the appeal site towards the back of Barrowfield Cottage, Keystoke Lodge and Oak Hill. Point 2, the aesthetic views of the rural land as a backdrop to the village, given that the site is a preserved late medieval enclosed open field created by a local arrangement and exchange. Point 3, the illustrative views of the historic development of the settlement, namely that through the views towards the back of Barrowfield Cottage, Keystoke Lodge and Oak Hill, one could appreciate how the settlement of Churchill had grown. And point 4, the views towards the church from and through the appeal site. Points 1 and 3. There's considerable overlap between Dr. Hudson Macaulay's points 1 and 3, given that they both relate to what historic or architectural interest one can glean from the views towards the back of Barrowfield Cottage, Keystoke Lodge and Oak Hill. None of these buildings are designated or non-designated heritage assets. There is no evidence before the inquiry to support the view that any of these buildings have any architectural or historic interest. Indeed, the latter 2 buildings were constructed in the late 20th century, as will be evident from the site visit. It is unclear when Barrowfield Cottage was constructed, but it is notable that it does not appear in any of the Ordnance Survey maps up to 1943. But again, there is no evidence suggesting it has any architectural or historic interest. The views towards these buildings are not design views. As to the suggestion that these views inform someone about the character of the village or how the village has grown, there was no actual explanation to how these buildings achieved that. Indeed, one can see the back of 3 buildings, but that does not meaningfully provide insight into how a settlement has grown. That is particularly the case when one considers that 2 of the buildings are recent additions, and thus any appreciation one can glean about the settlement is not in a historic context. Furthermore, even with the development proposal in situ, views towards these 3 buildings will still be provided. To the extent that they will allow one to appreciate how the settlement has grown, that will remain the case. It is suggested that the character of that view will change, being that one will experience the view from a residential development as to opposed to a pastoral field. But that's too simplistic. Indeed, rhetorically, one asks, what heritage is lost through views of modern buildings being seen in the context of other modern buildings? Point 2. Dr. Hudson Macaulay relies on the aesthetic value of the site, which she says is derived from the site being a preserved, late medieval enclosed open field. It is important not to confuse landscape and visual harm with heritage harm. Indeed, as Dr. Hudson Macaulay conceded, one could construct a village today with significant aesthetic value and no corresponding heritage significance. Thus, the exercise is to understand what in heritage terms is important about the site being a preserved late medieval open field. It would be wrong to conclude that the site has attractive qualities and then try to assign that some heritage significance. It was agreed that when we are trying to discern what is special about the site in historic terms, one of the factors we ought to have regard for is the rarity of it. This is relevant in that the site is probably the most commonly found in the county, probably the category most commonly found in the county. This is derived from the Avon Historic Landscape Characterization, which identified 32 categories of landscape types and identified late medieval enclosed open fields as the most common. Thus, the starting point is that the site's historic interest is already limited, given how common this type of historic landscape is. However, any perceived interest is further eroded by the fact that far from being a preserved or fossilized, per Dr. Hudson Macaulay's language, late medieval field, the site has substantially changed since the 19th century. Indeed, when one examines the 1840 tithe map and the 1888 first edition Ordnance Survey map, it becomes apparent how many changes have occurred. Firstly, the field boundary of the site derived from the 20th century. Indeed, the northern field boundary of the appeal site does not align with the northern field boundary on the 1840 and 1888 maps. Similarly, the southern boundary has almost entirely changed. Thus, as a matter of fact, Dr. Hudson Macaulay was incorrect to describe these as historic field boundaries. The site in its current arrangement is relatively recently formed. Secondly, the historic field was divided into 2, depicted as plots 206 and 207 on the 1840 map. However, the site in its current form, notwithstanding that the historical site has lost various parts, is divided into 3 fields. Thirdly, the site now has a modern post and rail fence running through it, and thus this prominent field boundary detracts from any sense of this being a medieval field. Fourthly, the 1888 map depicts 2 public rights-of-way running diagonally across the site. However, one of these routes has now been formally lost. Fifthly, there is now the presence of the menage and horse paddock, which again provides a modern presence on the site. Sixthly, the site now has the backdrop of a modern school. And seventhly, the field evaluation showed no buried archaeological remains within the appeal site, which is consistent with the point that the site does not have any historic interest. Thus, it is not accurate to describe it as a preserved late medieval century field. Rather, as Mr. Sutton described it, it is a very poor example of the most common type of historic landscape type. Dr. Hudson Macaulay did not dispute any of the above changes to the site as compared to the historic field. She also acknowledged that she had not realised any of these changes when she came to produce her evidence. It was therefore surprising, to say the least, that she was unwilling to make any adjustment to her conclusions about the scale of heritage harm, respectfully demonstrating the unwillingness to properly engage with what was actually special about the site and how this contributes to heritage interest. Furthermore, the argument about the site being valuable as an open field defies scrutiny when one considers that the conservation area boundary is drawn to exclude the northern field of the site. Indeed, both Mr. Cook and Mr. Sutton explained that in terms of the site being an open field, there is no distinction between the north and south. While the north falls within the setting of the conservation area, it is not afforded the same statutory protection as the south. If truly what was valuable about the site in heritage terms was its openness, the conservation area boundary would reflect this and cover the full extent of it. That is not in any way to attack the boundaries of the designation, far from it. The appellant has at no stage sought to challenge the lawfulness of the designation. To the contrary, Mr. Sutton agreed that the conservation area does provide historic interest, including along Front Street, where one encounters the suite of interrelated heritage assets. However, not all parts of the conservation area provide that historic interest, which includes the appeal site. Thus, examined accurately, as Mr. Sutton has done, this is an unremarkable field that provides no historic interest. Dr. Hudson Macaulay sought to argue that views of the church contribute to the significance of the conservation area. The views of the church as a designated heritage asset are considered below. However, it appears that the council is seeking to use one heritage asset, namely the church, to bolster their arguments concerning the other asset, namely the conservation area. When asking examination chief why the conservation area boundary had been drawn to exclude the northern field, Dr. Hudson Macaulay explained that the significance of the conservation area was about the village, not about the church, and thus the church and northern field were excluded from it. Mr. Sutton did not disagree. What was historically significant about the conservation area is the suite of listed buildings that run across Front Street and form the core of the village. But what flows from this is that if the church is not what is significant about the conservation area as its own discrete heritage asset, it is illogical to suggest that views of the church from the appeal site contribute to the significance of the conservation area. Putting it another way, if the conservation area is not concerned with the church, it is unclear how effective views of the church could harm the conservation area. Accordingly, any harm associated with the views of the church does not lead to a corresponding harm with the conservation area. However, for the reason below, there is no harm to the church in any event. Other arguments. It is worth noting that the council advanced other arguments to Mr. Sutton as to why the conservation area is significant. It appears to be suggested that given the site is partly within the conservation area, that indicates that the site has heritage interest. That argument is devoid of sense. The designation exists to ensure that what is special about an area is conserved and enhanced. The land does not derive heritage interest because of the designation. Indeed, not all parts of a conservation area will contribute towards its significance. This is recognised by paragraph 207 of the framework, which says, at its outset, not all elements of a conservation area or World Heritage Site will necessarily contribute to its significance. This is also consistent with the report concerning the Conservation Area Management Plan, which says, and I'll take that quote as read if you consent, sir, and 76, it is similarly consistent with Dr. Hudson Macaulay's evidence, wherein she contended that parts of the conservation area actually detract from its heritage significance. It was suggested at one stage that statutory duties in the Listed Building Act and the NPPF are not aligned in this respect. I was going to submit authorities to highlight that there is no inconsistency between the framework and the Listed Building Act, as there are ample authorities supporting this proposition. It was agreed outside the inquiry that paragraph 204 of the framework is not inconsistent with, and I should say, with the Listed Building Act. And thus, ultimately, its application comes down to a matter of planning judgment. So, if I can deviate from my script here, sir, just my learned friend's discussion at paragraph 17 of the framework. And Fred said you can't use the framework to construe the 1990 Act. To be clear, sir, we say, and it's a matter of common sense, not all elements of conservation area have or contribute to its historic interest or its significance. Which areas do and which areas don't are matters of your judgment, and neither Section 69 of the Listed Building Act or paragraph 207 of the framework suggests anything contrary. So it's purely for your judgment as to which areas do actually have that historic interest and contribute to that significance. Other appeal decisions, sir, returning to my script. The Council sought to align a suite of appeal decisions in the vicinity of the appeal site to bolster their arguments. The first and most obvious point to note is that each appeal is determined on its own merits. We do not know what evidence was presented to those inspectors, and thus one should naturally be cautious about trying to read across conclusions from one appeal to the other on such site-specific issues. Secondly, in none of those appeal decisions did the inspectors find harm to the conservation area owing to the 4 points Dr. Hudson Macaulay relied on above. Thus, even the arguments the Council will now rely on to support a finding of harm to the conservation area cannot be read across to those appeals. Thirdly, in each of those appeals, the inspectors found harm to the views of those appeal sites from Front Street, given that it was being proposed to have prominent buildings along the frontage of Front Street. However, the appellant is not proposing that here. The indicative site layout shows housing pulled back from Front Street and the provision of public open space, tree planting, and a balancing pond along Front Street. Whilst this is illustrative, this demonstrates that it is entirely achievable to provide 62 dwellings on the site without providing imposing dwellings across the frontage of Front Street, as with those other appeals. Thus, those appeals do not provide a proper basis for comparison. Accordingly, in summary, what the Council has sought to do is identify an open field in a conservation area and seek to attach historic interest to it. However, when it is forensically scrutinised, it is apparent that this interest does not arise. The church, sir. The Council alleged that the harm to the church is less than substantial, albeit at the lower end of the bracket. Thus, necessarily, the harm that is alleged is the lowest degree of harm that could be found in respect to the asset. Mr. Sutton contends that there was no such harm. Views. It is correct that currently there are views towards the tower of the grade listed church across the site. However, after the development proposal, these views will remain. It is conceivable that some views along the public right-of-way, i.e. the only lawful area for the public to see the church and the appeal site currently, could be lost through houses, but equally, new public views of the church will be created through the provision of public open space. Indeed, one notes that public open space is proposed in the closest part of the site to the church in the illustrative master plan. The Council rely on the view of the church through the site access, best depicted by Dr. Hudson Macaulay's viewpoint 8. That is a seasonal winter view which is only available currently during the reduced sunlight hours of the winter. The church does not present itself as a landmark from this point, given that a landmark view necessarily suggests one where the asset stands out. However, were this view regarded as being important, there is no reason it could not be retained, as Mr. Sutton made out, without challenge. Dr. Hudson Macaulay also relied on other views that are not present. Indeed, he relied on views from the church to the appeal site. However, there was no such view. Similarly, she relied on views approaching the village from Front Street. But when one walks towards the village from along Front Street, one necessarily has one's back to the church. Thus, again, there is no such view. Relationship. The Council are unable to point to any relationship between the appeal site and the church, except for the fact that there is some indivisibility between the two. It is common ground that there is no evidence to suggest that the church and the appeal site were ever in common ownership or ever formed part of the same land parcel. It is also common ground that the church and the appeal site derived from different periods. Indeed, the church origins are from the 12th century, 12th or 13th century, I should say. The appeal site, being a late medieval enclosed open field, derives its origins from the late 17th century, albeit given the various changes to the appeal site as we find it today in terms of the boundaries and the other points addressed above, it derives from its origins from the 20th century. Thus, the church and appeal site share no temporal or historical connection in this respect. This is relevant insofar as the Historic England GPA 3 acknowledged that settings of historic interests, assets, which closely resemble the setting at the time the asset was constructed or formed, are likely to contribute particularly strongly to significance. We have no evidence as to what the setting of the church was in the 12th century. However, we know it did not resemble the current setting given the surrounding changes, including the appeal site and the school. Thus, there is no historical relationship between the site and the church to be harmed. Not a historic setting. Having regard to the points raised in respect to the conservation area, it must be acknowledged that the site does not provide a temporal historic setting to the church. nor does the site retain any special historic interest itself, being a poor example of the most common landscape type in the county. Thus, while one currently experiences views towards the church from the site as a pastoral field, there is no evidence that the site being an open field contributes to the historical significance of the church. The significance of the church is experienced in historic terms in its immediate surrounding, i.e. the churchyard. In this location, one can readily appreciate the architectural and historic interest of the church. It was surprising, therefore, to read Dr. Hudson Macaulay's evidence that views towards the church from the site only play a slightly less significant role in the church's significance in comparison to those closer to the church and around the courtyard. This suggestion that views of the church from the site are only slightly less significant than the views in the churchyard demonstrates a profound misunderstanding as to the historical significance of the church. From the churchyard, one experiences the church in its historic significance setting. Put another way, when one can be conceptually transported back to the church's origins and its evolution from the experience at the churchyard. In contrast, one is not transported back from the appeal site. While one able to transport someone from the 12th century or later to witness the church from the site, they will immediately be struck by the significant differences in the site itself. They would thereafter query the changes to the foreground of the church which dominate its view, i.e. the converted 16th century cottages where no harm is alleged, not to mention the presence of the school. Thus, one is not gaining any particular appreciation in historical terms of the church from the appeal site. That would be lost through the introduction of built form. Moreover, it is worth noting that there are no designed or particularly significant views of the church from the appeal site. Rather, it appears as a rather generic point that you can see a church from what is currently an open field. Seemingly, the council's point is that putting development next to listed buildings must necessarily be harmful in heritage terms, even if no identified historic interest is lost. Focal point. Dr. Hudson Macaulay sought to argue that the historic heart of the village grew around the church and thus the church remains a focal point. However, there's no evidence at all to support this contention. Dr. Hudson Macaulay sought to rely on Appendix 4 attached to a proof to support the view that the church, that Churchill did at one stage revolve around the church. However, the particular passages that were cited had nothing to do with Churchill. They were broad and generic discussions about heritage assets generally that were not discussed in any way that was relevant to Churchill. Dr. Hudson Macaulay also relied on earthworks lying to the north around the church as supporting this view that Churchill grew up around the church. However, no evidence to substantiate that point was provided to the inquiry. Further, Mr. Sutton explained in his evidence in chief how the earthworks did not support that contention. Rather, as Mr. Etchell stated, this is not one of the occasions where the settlement has grown up around the church. Thus, the church is not the focal point or core of the settlement. However, even if that were wrong, it remains to be seen how that would be compromised by providing housing around it. The point is that the church is currently a landmark feature, but with residential development, it will continue to be a landmark feature. Admittedly, it will be experienced in a different context, but that does not amount to heritage harm. Indeed, there is nothing of heritage significance about the experience of seeing the church from the site currently. Even if one regards this to be a pleasant view, that does not, and admittedly it is, that does not afford it heritage significance such that one is enjoying the church from its historic setting or in some way that allows us to deepen our appreciation of it. Accordingly, the appellant contends that there is no heritage harm. In the alternative, any perceived heritage harm could only be at the lowest level, given that there is no identified historic interest being lost to the development proposal to either asset. 5-year supply and the extent of the shortfall. Whilst it's common ground that the council do not have a 5-year housing land supply, there remains numerous issues in dispute on the issue of housing delivery. I quote there from the Hallam Land Judgment. I'll take that as read if you're content, sir. And at 107, I say, it is worth exploring each of the factors the Court of Appeal held were relevant to inform the weight to the benefits or disbenefits of a proposal. These closings then proceed to discuss other issues that are relevant to the question of housing need. A broad magnitude of the shortfall. So there is a vast difference between the parties as regards the shortfall. The council are at 4.9 years, whereas the appellant is at 2.95 years. That 2-year difference of supply amounts to a significant divergence when one considers it amounts to a shortfall of either 135 dwellings or 2,982 dwellings, respectively. Which figure you prefer relies on the evidence you heard during the round table session, which I do not repeat here. And sir, just deviating from my script there, at paragraph 20, sir, of my then friend's closing, at 20 subsection 1, he says that the range goes between 2.5 to 4.9. He says the difference is likely to sit somewhere in the middle. So we invite you to adopt a proper assessment of the shortfall, not a crude exercise that's being advanced there. How long it is likely to persist, what is being done about it. The Council have provided no trajectory whatsoever indicating what will happen to their supply after 2026. Thus, the requirement that one has an appreciation of where growth will go for years 6 to 10 and where possible years to 11 to 15 per paragraph 68b of the framework is not satisfied. Further, there is no evidence before the inquiry as to when the Council supply will be restored. Thus, on the available evidence, there is no credible end in sight for the Council supply problems. It was suggested that the Council may be able to restore their supply through the adoption of their emerging plan. However, given that this emerging plan can be afforded no more than very limited weight, plainly one can have no confidence in the emerging plan resolving the situation in its current form. And again, deviating from my script and just picking up my learned friend's paragraph 22, he says at the end, there is every prospect that it will be adopted and the shortfall corrected in around 19 months. So I have never witnessed a local planning authority place such emphasis on an emerging plan, which they themselves acknowledge should only be afforded very limited weight. It's a matter for you, sir, whether that is a curious feature of the Council's case. Paragraph 111, sir. The Council also sought to argue a new point, not in their proofs of evidence, that the flexibility inherent in the development plan through policies such as CS32, which allow for up to 25 dwellings adjoining settlements, could remedy their 5-year supply. That was a particularly bad point, given that these flexible policies have been adopted since January 2017, and yet the Council are only able to reference 2 sites, totaling 75 units, that have been permitted on this basis. So again, if I can deviate from my script. It's subsection 3. It's the next subsection in my learned friend's closing. I think that's being suggested, or whether it's implicit criticism, it said Mr. Tiley has not investigated what contribution has been made by this class of sites since 2017. First point to note, sir, this is a point made on the fly by the local planning authority. That the remedy to their 5-year supply is this flexibility. So it's clear as day when Mr. Tiley didn't investigate that. It wasn't a point that the Council raised until the same day he gave evidence. Similarly, sir, it's not for Mr. Tiley to investigate it, because his point is that's not credible. It's the Council. It's the Council who rely on this flexibility as their argument to you as to what is being done about it to remedy their 5-year supply. So for the Council to properly put that point, it's for them to fashion you with that evidence. They haven't. All they've done is say, we've got 2 sites that have been granted in over 5 years. Hardly a compelling point. So back to paragraph 112, sir. Not only does that underscore that it is daft to suggest that the Council's significant shortfall will be resolved through this flexible approach, but it also underscores that the flexibility introduced into the development plan has failed, given that these policies have been unsuccessful in meaningfully contributing to growth. The Council sought to suggest that their position is improving the respect to 5-year supply, which suggests it could be remedied in the future. Not only is that untrue, given the extent of the shortfall, but it also relies on incorrect assertions about the housing delivery test. The housing delivery test shows how many homes have been delivered in the past compared to how many homes were required as a minimum by the housing delivery test at that point. It therefore provides no indication of the future direction of travel. Moreover, the way in which the housing delivery test results are calculated changes annually, owing to different adjustments applied by the government. Indeed, a grace period was allowed in respect to the housing delivery test during the pandemic to reflect difficulties faced by the construction industry. Thus, seeking to trend these results, as Mrs. Richards has done, does not compare apples with apples. Mr. Tiley sought to remove these adjustments to provide a fair comparison within Table 4.1 of his rebuttal. This demonstrates that the results for the Council are not improving, but rather the results have remained broadly consistent and, if anything, have recently reduced. It is worth noting that no alternative table providing pandemic-based adjustments was provided, and Mr. Tiley was not challenged on the point. Finally, the number of homes delivered will be largely influenced by the number of homes committed. In North Somerset, the number of committed homes have reduced significantly over recent years, such that it would be expected that the 5-year housing land supply position will similarly worsen in the future. How much the development will meet? It was suggested to Mr. Tiley that as the development proposal provides for only 62 dwellings, this fetters the weight that can be afforded to it, in the context that this amounts to less than 2% of the council's shortfall. Properly examined, this point lacks any logical sense. Firstly, medium sites such as the appeal site are the sort of development the council need, as they are the sites that are often built out relatively quickly in accordance with paragraph 69 of the framework. Indeed, as Mr. Tiley stated, had the appellant been promoting a large-scale site, that would not likely come forward in the short term to address the council's housing need, and thus this would temper the weight to it. Secondly, as Mr. Tiley stated, this would suggest that if the shortfall in housing was reduced to 135 dwellings, the appeal proposal would make a greater contribution to the shortfall in percentage terms, and thus would be given more weight. Such a proposition is perverse. How long it has persisted, and so if I can just again deviate from my script and go to paragraph 20 of my learned friend's closing. Just before my learned friend goes to subsection 1, the sentence beforehand says, neither Mr. Tiley nor Mr. Wakefield suggested any other matter is relevant in this case. That's wrong, sir. I'm going to go through a number of points that are relevant, all of which were addressed in Mr. Tiley's proof, all of which I cross-examined on. So there are other matters that are relevant in this case. How long it has persisted, the lack of a 5-year supply. The council have been unable to demonstrate a 5-year housing land supply since 28th of February 2014, i.e. over 8 years. Since then, there's only been a single written representations appeal where the inspector there found that the council did have a 5-year supply. However, as Mrs. Richards conceded, that conclusion was reached following no forensic scrutiny of the issue. Moreover, the inspector's conclusion was incorrect, given that at paragraph 5 of the decision, the inspector relied upon the conclusions of the examination inspector report, notwithstanding the fact that the examination report actually states, I reach no conclusion as to whether a 5-year housing land supply has been demonstrated. Thus, the inspector simply deferred to one of his colleagues, who he mistakenly thought had made a positive finding, when in fact they had not. Finally, there were inquiries either side of this appeal, where the issue was forensically scrutinised, and it was found that the council did not have a 5-year supply. The consequence of this is that there's been an undelivery against the adopted housing requirement, which we know to be significantly too low, of 3,466 homes. Pausing there, sir. So sorry, we're back to paragraph 20 of my learned friend's closing. My learned friend, at Roman numeral 24, he says if you look at the list of appeal decisions in the past, they suggest a supply generally in excess of 4 years. 2 points to make about that. One, that is not a good thing. I don't know why the local planning authority would say we've got a pattern of not delivering housing. That's not a point in their favour. But two, sir, if that being correct, if they have a pattern of being in excess of 4 years, and you accept Mr. Tiley's evidence that they're now below 2.95 years or below 4 years, it completely demolishes their argument that things are improving. Back to paragraph 123, sir. Mrs. Richards also accepted that the potential for economic growth across the district has been compromised owing to the lack of housing delivery. Indeed, it was also accepted that this will have been a factor that has contributed to the affordability of housing in North Somerset, worsening by 51% in the last decade, being the second worst decline of any local authority in the southwest of England. Finally, the fact that the council have been unable to demonstrate a 5-year supply for so long suggests that they will have significant difficulty demonstrating one in the future, given the significant undersupply that will need to be addressed. Unreliable predictions. The council, and specifically Mrs. Richards, has a history of consistently being significantly wrong in predicting the council's supply. Indeed, as demonstrated in Table 9.1 of Mr. Tiley's proof, Mrs. Richards has consistently reported to inspectors that the council will deliver one figure, i.e. 1,765 per annum on average in the Sandford appeal, and then they deliver a much lower figure. They delivered 856 per annum on average over that period, so less than half. These overestimates have been between 184% to 220%. 2 points were advanced to try and explain this. The first was the pandemic, however, that is objectively incorrect. As demonstrated at figure 9.2 of Mr. Tiley's proof, the Council's over-predictions were more inaccurate prior to the pandemic than during it. Indeed, the Council performed better than previous years during the pandemic, albeit still much lower than they predicted or what they were required to deliver. The second point advanced by Mr. Leader was that this was owing to land banking. However, there is no evidence whatsoever submitted to the inquiry to substantiate this position. Moreover, in no way does it diminish the point that the Council are consistently wrong in predicting their supply. Thus, we invite you to treat with severe caution the Council's reliability in being able to judge their own onward supply. Pie-in-the-sky figures. It also ought to be borne in mind that the Council's claimed supply over the next 5 years suggests that they will deliver on an average of 1,440 dwellings per annum. This compares with an average delivery rate of 856 dwellings per annum over the last 5 years and 732 over the last 10 years. To put that into context, the Council are claiming that they will deliver consistently every year for the next 5 years the greatest housing delivery they have ever achieved in a single year in their history since 1981. That in itself demonstrates that this is woefully unlikely. However, that shows the extent of the problem. Even if the Council achieve these record numbers, they still don't have a 5-year supply, and they still have a planned period shortfall. Thus, we invite you to stand back and recognise that the Council's estimated delivery is pie-in-the-sky thinking, against the backdrop of an authority who have consistently overestimated their delivery. Affordable housing. The most recently tested evidence based from the Council that seeks to quantify the need for affordable housing is the SHMAR, which informed the core strategy. It was acknowledged that there was a total need for 9,944 affordable homes between 2009 to 2020. However, over this period, we know that there has, in fact, only been 1,272 delivered. Thus, there was a shortfall of 8,672 fewer affordable homes delivered than needed. That is the need, and plainly eye-watering. The need, when it comes to, I should say, sir, those figures were agreed. The need, when it comes to affordable housing, is a different feature to the requirement. Indeed, the 30% requirement for affordable housing within Policy CS16 does not solely reflect the affordable housing need, as other considerations such as viability and scale of development are similarly factored into this policy. Thus, the requirement for at least 150 affordable homes per annum over the planned period is not a reflection of those in actual need of affordable homes across the district. However, even if one were to solely focus on this figure, the Council would still have a shortfall in delivery of 265 affordable homes. On either view, the policy-compliant contribution of affordable homes being 19 dwellings is still a substantial benefit of the scheme. Whether it would be a sustainable location for the proposed development, having regard to the development plan and national policies. The appellant accepts that the development proposal conflicts with the development plan when read as a whole. However, it is common ground that the most important policies for determining the application are out of date, and thus the appellant's case is that only limited weight should be afforded to this conflict. Yes, sir. The strategy that failed. It was common ground that the development plan strategy has failed. There's a curious history to the adoption of the development plan. The core strategy was adopted in 2012, but then after a legal challenge to the plan's housing requirement, the plan was remitted back to the Secretary of State for re-examination. This culminated in policy CS13 being adopted in 2015, with the following policies being re-examined and later adopted in 2017. These policies were re-examined on the basis that they were inextricably reliant upon policy CS13. Indeed, it is unsurprising that if there is a flaw with the housing requirement policy, it necessarily follows that there will be a flaw with a suite of other policies that are reliant on this housing requirement, such as the settlement boundary policy or housing numbers policy. Policy CS13 requires the delivery of a minimum of 20,985 dwellings within North Somerset up to 2026. The appropriate level of new homes will be reviewed by 2018. Even on the Council's case, this minimum housing requirement will not be achieved by 2026. Instead, even assuming all of the Council's assumptions for the delivery of housing for the next 5 years are correct, which they are not, the Council will still only deliver 19,447 homes over the plan period, i.e. a shortfall of 1,440 538 dwellings. Thus, the development plan strategy has failed. The plan also fails to accord with the following paragraphs of the framework. I'm going to take those paragraphs of the framework as read, sir, if you're content, and go to 141. In each respect, the development plan cannot be said to achieve this, given the presence of the minimum housing requirement not being satisfied. It is also worth acknowledging that the minimum housing requirement itself has not only not been achieved, but it is too low and was not meant to be relied upon post-2018 in any event. It is common ground that policy CS13 is not based on an MPPF compliant assessment. Indeed, the examination inspector of policy CS13 acknowledged the fact at the point of adoption. I'll take that quote as read. The intention was that the policy could be adopted subject to a review by 2018, such it was only intended to be a stepping stone, as acknowledged by the examination inspector. Again, I'll take that as read. However, whilst the council commenced with the review, this was abandoned. The consequence is that the housing requirement, which was explicitly not intended to be relied upon post-2018, still forms part of the council's housing strategy. Indeed, Mrs. Richards accepted the housing requirement is now demonstrably too low, which is reflected by the fact that the standard method provides for a minimum housing need that is 33% higher than the development plan requirement. Thus, the following points become apparent. The development plan's housing requirement is not meant to be relied upon after 2018. The requirement was never MPPF compliant. The requirement was always anticipated as being too low, which proved to be correct, and yet the council have still been unable to meet it. Mr. Stevens accepted that this planned period shortfall meant that the strategy had failed, and consequently this reduced the weight to the development plan. Tilted balance. Sir, it is common ground that the most important policies, in fact, sir, I'm going to take the tilted balance as read, because there doesn't appear to be anything between us on that, if you're content. Policies. It is common ground that there is an in-principle conflict with the development plan through policies CS32 and CS33. The conflict with these policies derived from the fact that the site is outside, but adjoining the settlement boundary and in excess of 25 dwellings. However, the weight to be afforded to that in-principle conflict is limited, given that the council do not have a 5-year supply, the council having acknowledged planned period shortfall. The strategy underpinning these policies has failed. The housing requirement underpinning and informing these policies was never NPPF compliant and was not intended to be relied upon beyond 2018. The fact is identified in the Hallam Land judgment, the constrained nature of the authority, the fact that the council acknowledged that they need to be granting permission on sites outside settlement boundaries on greenfield sites, and finally, that the fact that the flexibility that was built into these policies has not worked, only delivering 75 units that we're aware of since 2017. As regards the other policies relied upon by the council, conflict with these policies flow from the findings in respect to landscape and heritage. The only residual point of contention between the witnesses relates to whether it's correct to find conflict with policies CS5 and DM10 of the development plan in respect to visual harm as opposed to harm to landscape character. Mr. Cook and Mr. Wakefield have relied on the literal language in these policies to inform their view on this. However, as Mr. Stevenson unequivocally agreed, before unfortunate attempts to row back his answers in re-examination, the policy interpretation point is ultimately academic, given that either way, there is still conflict with the development plan as a whole, and either way, one is still required to factor visual harm into a planning balance as a material consideration. Benefits. It is common ground that the weight to be afforded to market and affordable housing should each be substantial. I'm pausing there, sir. My learned friend at paragraph 28, he records the weight as being significant. 2 points. One, in my learned friend's opening, he invited you to afford it substantial weight, and that's paragraph 2 of his opening. The quote is, in that context, whether or not the tilted balance is triggered, the delivery of 60 new homes, including a policy-compliant contribution of 30% affordable homes, ought to be afforded substantial weight. And you'll recall Mr. Stevenson accepted that it should be substantial weight, given that the council do not have a 5 supply, and substantial being something greater than significant. And so I say plainly, if the extent of the shortfall is greater than the council allege, then this weight would naturally increase, per Hallam Land. It is similarly agreed that the economic benefits associated with the development proposal are significant in accordance with paragraph 81 of the MPPF. Mr. Seaman accepted the language used by Inspector Wyborn in the Sevington appeal could be read across as being appropriate to the development proposal. Similarly, the proposal offers a betterment in terms of surface water drainage and improvement to local service and facilities. I'm very conscious of the time. I know we need to get out. BNG. The appellant submits that the development proposal has the potential to deliver 44.13% biodiversity net gain, and this is a substantial benefit to the proposal. The Council sought to make heavy weather over the question of biodiversity net gain. The Council provided with the appellant's BNG calculation prior to the exchange of proofs on the 6th of May. It is note that they never had made any mention of it until after Mr Farmer had concluded his evidence. The Council have not contested Mr Farmer's calculation, rather they take a point of principle that given this is an outline proposal, one should essentially ignore the calculation. The appellant has offered a condition to secure at least 20% BNG, which entirely aligns with the Rainham Secretary of State decision, where the Secretary of State afforded the 20% provision of BNG substantial weight. Thus, you can have confidence through this condition that there will be a substantial BNG. The provision of BNG is identified as a key part of the environmental objectives of sustainability. Its importance is foreshadowed by the Environment Act, which includes a requirement for 10% BNG, albeit that's not currently in force. Indeed, any countervailing environmental harm, namely to the character and appearance of the area, will need to be balanced against this positive environmental gain. The fallacy of the Council's points on BNG are properly exposed when one recognises that applying their logic, an outline proposal that only has the potential to deliver 0.1% BNG is to be judged in exactly the same way as a proposal with the potential for delivering 44.13% BNG. Such a closed-minded and artificial approach would naturally lead to opportunities to secure environmental improvements being ignored, not to mention material consideration being left out of account. And my final point, happily, constrained authority. So oftentimes the rhetoric of an inquiry elicits the suggestion that there are better sites out there. However, that proposition does not bear fruit here. As Mr Stevens acknowledged, there is no requirement for the appellant to demonstrate that there are no better alternative sites. Moreover, there is no evidence whatsoever of alternative available sites. Indeed, if that were the case, the Council would presumably not have a 5-year supply deficit for over 8 years with no end in sight. While the Council have pointed to the Ward Armstrong sensitivity study showing broad areas that were identified as being of lowest sensitivity in landscape terms, there is no evidence whatsoever as to their availability, nor as to what other site-specific issues those sites might face. Moreover, here we are faced with an authority that is particularly constrained. As the emerging plan consultation documents demonstrate, three key constraints in North Somerset which cover the majority of the district, the Greenbelt, Flood Zone 3 and Mendip Hills A1B. Indeed, the extent of the constraints is such that the Council are already acknowledged that exceptional circumstances are made out to justify Greenbelt release. Even in the context of the Council will still need to identify 2,850 dwellings to meet their minimum requirement. Whilst the emerging plan should only be afforded very limited weight, it is telling that this early on into its consultation, the Council are already recognising the need for Greenbelt sites before even reaching their minimum housing requirement. Thus, it is clearly inevitable that in this district, the Council will need to start relying on sites with adverse land use impacts. In that context, the appellant submits that any land use impact associated with the appeal site cannot be so significant to justify refusal, balanced against the benefits proposed, and in the context of this being a settlement with a capacity for this quantum of growth, and the fact that the Council face such a persistent and significant 5-year housing on supply shortfall and are a highly constrained authority. Those factors taken together suggest that if one were to favour the land use impacts, even alleged by the Council, we say that in this authority, who are plainly crying out for sites, those harms do not significantly and demonstrably outweigh the benefits. Accordingly, sir, subject to the conditions in Section 106 agreement, we respectfully invite you to grant permission. So those are my submissions, unless I can assist you further.
Thank you very much. Okay. Thank you for those. Costs? Any applications for costs at this stage?
Not from the council, sir, no.
No.
Likewise, sir.
No. Okay. Documents, outstanding documents. So I agreed the 24th of June for the conditions and the draft obligation. I should draw a line. I didn't see you at the start. I needed to mention the comments that we received from the interested party yesterday. Very surprised to know that, having heard the closing submissions, I'm not requiring any further evidence from yourselves in response to those points. Is there anything else that anyone wished to draw to my attention?
Were you fashioned, sir, with the inquiry document list? We have been compiling that list.
It's been coming through daily via email, so I've had that. Gratefully receive another electronic version today. Thank you.
No, sir, just to thank you and the council for hosting us.
Okay, as I said, I didn't tell you at the start, I'm going to do my site visit tomorrow. I want to take stock of everything and I'll have more time to view the various locations. If anybody sees me, please don't approach me. I won't be discussing the scheme with anybody, but I will do that through the day tomorrow, starting tomorrow morning. Okay, so attendance sheet, back to me, please. Is there another meeting starting in here immediately? Right, so we've got to clear the room now, yeah? Okay, so we need to rapidly clear the room. So it remains to say thank you for everybody, the interested parties that have come and given evidence to the inquiry. The manner in which the inquiry has been conducted has been helpful to me, so thank you to everybody that's engaged with it. So unless there's anything else, at 25 to 2, I'll close the inquiry.